Good morning. I just wanted to check my audio. Can you all hear me?
Yes, I can hear you, Alicia.
I can hear you, Alicia.
Thank you.
Ben, can you test your audio now before the hearing starts?
Sure. Can you hear me okay now, Zoe?
I can, thanks.
Hi, Melissa. Good morning.
Good morning.
Hi, Melissa. How are you?
Good. How are you today?
Good.
Okay.
Thanks so much for doing this over Zoom.
Absolutely.
Good morning. Joan Drake just arrived.
Madam Hearing Examiner, if you're talking to us, you're on mute, so we can't hear you.
Thank you, Alicia. Some people like it better when I'm on mute. Anna, I was asking if you could put another O in Melissa's last name.
Oh, yeah.
So it could be Goodson.
Okay, just a minute.
Thank you. Are we going to have anything procedural that we need to deal with before we begin? I just want to let people know Anna has already put the YouTube link on the commission's webpage. So if you have people that you want to listen on YouTube that we didn't send invitations to, that's kind of one of the reasons that I asked people who we needed to do the Zoom invitations because we're trying to stream the hearings and so that other people can listen on on YouTube. I have been advised by our IT department that you can't do both at the same time, or you will get a like a rebounding on the audio, which will be uncomfortable. Anybody have any idea who these two phone numbers are?
Good morning. One of the phone numbers I believe is for me, Julia Brogy with Holland and Hart.
Okay,
Can you spell your last name?
Yeah, it's BROGGI,
Thank you.
and I'm appearing with Austin Reichschuff.
Very
okay.
good.
Are you the 505?
Yeah, 505-228-1764.
Okay,
I'm sorry,
So-
I'm still having trouble accessing it on Zoom. But as we discussed at the pretrial on Monday, we're going to ask that I be excused because Mr. Reichschuff is primarily handling the matter.
okay. Any other procedural things that we might want to discuss before we go on the record this morning? As some of you who were here a few minutes ago, Anna has, I believe, our exhibits. Is that right, Anna?
Yes, I have 27 documents, including unmarked exhibits, a number of unmarked exhibits.
Okay, and are you sharing your screen right now?
No,
Okay, all right. Okay, well, we'll wait a couple more minutes, because I don't believe we have everyone yet.
Madam Hearing Examiner, I think the only thing procedurally we'll need to do is admit exhibits for those witnesses that have been waived. And aren't appearing at the,
Right,
Yeah.
and we can do that in the due course of, I mean, each of the parties can, for example, you could start out with yours if you wanted, even though that's not how the numbers will follow, but
Yeah.
I think we'll be able to figure it out.
thank you.
Am I incorrect, or did I just print did I print duplicates of all those exhibits that kept flying around yesterday? Or potential discovery? Are some people or some parties proposing the same interrogatory responses multiple times?
I think there was some duplication between the parties because they didn't, for example, SPS said that they might on redirect introduce SPS's response to New Mexico Large Customer Group 2.1 and 2.2. And because we hadn't seen what exhibits New Mexico Large Customer Group was proposing to introduce, we didn't realize it was going to be duplicative. So some of that duplication might not happen in the actual hearing.
Okay.
And may I just
Right.
ask Ruth Sakia to just test her audio so we know it works?
Can you guys hear me?
Yes.
I can.
Okay.
Good morning.
you.
What's
Good
the
morning.
design behind your head?
It's just Excel's and Excel Energy Swirl.
Okay.
Nothing
I guess
fun,
it's better than them tattooing you, huh?
right?
And it looks like Ms. Lees has one on top of some solar panels, maybe?
That's right.
Okay.
That way you
And-
don't have to see my messy office.
Oh, and look, and Mr. Elsie has the wind.
I have the wind.
Okay, is that hail or Sagamore?
I'm not sure if it is either. It may be generic.
Okay. Very well. Oh, there's Mr. Hello.
Good morning.
Okay.
Madam Hearing Examiner, this is Joan Drake. The only
Hi,
other,
Mr.
I think, procedural question I had is how you wanted to deal with our request to take administrative notice of various materials from case number 17-00044. And I believe other parties may also have identified materials from previous cases.
Well,
I'm not
are you,
sure that we're going to need to cross-examine on those, but we would like to at least have the option of referencing them in any post-hearing filings.
oh, okay. I don't know. I mean, I guess we can handle it at the beginning under procedural matters.
Okay.
You know, that way we can have those things out there just in case somebody does cross-examine on them.
That
I
would
just
be
have a quick question on that, because I just want to make sure if we just want to cite to a PRC decision in our brief, but we're not questioning a witness on that
Yeah,
order, we don't need you to
No.
take administrative notice of it, correct? That's just
Nope.
that we're citing. Okay, I just want to make sure, because that's what I thought, but this has been a bit of a confusing conversation the past 2 days about
yeah,
this.
no, no, I'm not aware that you actually have to.
Yeah,
I-
I've never had to do that if I want to cite to
Yeah.
something in a brief.
Right. In I don't know, you know, I guess I've always thought taking administrative notice of commission cases, as opposed, you know, I mean, I can understand the difference when you're taking administrative notice of something outside your agency, but, you know, I mean, I guess if you're taking, you know, you're kind of highlighting it. You're trying to say, okay, hey, you know,
I
I'm
just wanted to
highlighting.
ask because I spoke
That's
to a
fine.
couple parties about it.
Yeah.
People getting nervous that they wouldn't be
Yeah.
able to cite to prior
No,
commission
no.
decision briefing. So,
No,
okay.
there's enough stress everywhere. No need to stress on that. Okay.
That's right.
Okay. It looks like to me that I think we have all the parties now. So I think we can go ahead. We're just to let parties know we're already streaming. So everything we're saying is out in YouTube land, you know, and have said. And if you have your camera on, that's out there too, you know? So just a word to the wise, I've always heard is sufficient. So very well, let's go ahead then. Melissa, can you hear me all right, or would you prefer I put my headphone on?
I can hear you just fine, and I'm ready to go.
Okay, excellent. Okay, well, I will remove the headphone then, which I don't know about you all, but tends to give me a headache, and maybe it was just that 5-day hearing that I got a headache from. But good morning. My name is Elizabeth Hurst. I am the designated hearing examiner in today's hearing for case number 20-00143. And this is in the matter of Southwestern Public Service Company's annual 2021 Renewable Energy Portfolio Procurement Plan and requested approvals therein. Proposed 2021 Renewable Portfolio Standard Cost and Reconciliation Riders, application for an RPS incentive and other associated relief. Along with me today is our court reporter, Melissa Goodson. Should anyone need anything to do with the transcript, they will need to contact her directly. It is my understanding that due to the abbreviated nature of the review period in this particular type of case, SPS has requested an expedited transcript in this case. Today is the date, time, and place for the hearing in this case. And we will, I'd like to indicate for the record that a notice of public comment was placed upon the commission's website to notify the public should anyone want to give public comment in this case. And no one contacted us to give that public comment. I'd also like the record to indicate that upon review of the commission's docketing records system, no one provided a written public comment in this case. And with that being said, if we could go ahead and get our appearances beginning with you, Ms. Lees, if you would just state your appearance for the record, please.
Good morning, everyone. Zoe Lees and Mark Walker here on behalf of SPS. With me today are also our two witnesses that will be testifying, Ruth Sakia and Ben Elsey.
Very, very well. And hold on one second and let me get let me get that off the screen. Looks like Bill came off. Okay.
Miss Hearing Examiner, it seems like Mr. Templeman is having trouble joining in.
Yes, I just admitted him again.
Oh, this is Bill Templeman. I'm on the phone for the moment. Can you hear me?
I can. Hello there, Mr. Templeman.
Okay.
Why don't you go
Good
ahead
morning.
and...
I apologize.
That's okay. Why don't you go ahead
I'm
and
not
enter
sure what
your
the-
appearance?
Yes, this is William Templeman on behalf of COG Operating LLP. And apologize for difficulty joining the video, but if it doesn't work out, I'll just participate by phone.
All right, sir. And I'll just start on the top row here. Mr. Lundeen, would you enter your appearance, sir?
Good morning, Madam Hearing Examiner. Robert Lundeen on behalf of the New Mexico Attorney General's Office.
Very well. Welcome back. Ms. Drake?
Joan Drake on behalf of Louisiana Energy Services, or LES.
Very well. Good morning. Mr. Rushoff?
Good morning. On behalf of the New Mexico Large Customer Group, I am Austin Rushoff, joined by Nick Stoffel and Julia Brogy. We also have Kevin Higgins here to testify later this morning. And Madam Hearing Examiner, if now is the appropriate time, I'd like to ask for Ms. Brogy to be excused for the remainder of the hearing, if that's okay with you.
Okay, let's get everybody's appearance on the record and then we'll deal with that. All right, sir? Okay. Ms. Zer?
Stephanie Zer for the Coalition for Clean Affordable Energy. Good morning, all.
Good morning. Ms. Coleman? You got to unmute yourself.
Thank you. Try again. Good morning, Katie Coleman for Occidental Permian Limited, OPL.
Good morning, Ms. Beatles.
Good morning, Sydney Beatles for Western Resource Advocates.
Mr. Bagatko.
Good morning, Madam Hearing Examiner. John Bagatko on behalf of NMPRC Utility Division staff, and I am accompanied by my sole witness, Alicia Leyva Tercero. Thank you.
Very well. Okay. All right. Did I forget anybody? Hello there, Mr. McMillan.
Hello. Michael McMillan, also on behalf of OPL.
Okay, very well.
I'm sorry, on behalf of who?
OPL.
Thank you.
OPL.
All right, I think we have all of our parties. Now we need to deal with some some procedural matters, and I believe Mr. Rushoff, you have asked that Ms. Brogy be excused from today's hearing, and is that correct?
That is correct.
And you can assure me that she's available, and if necessary, and that you are familiar with the commission's rules of procedure, correct?
Yes, that is correct.
Very well. Is there any objection to Ms. Brogy's being excused from the hearing? Hearing none, Ms. Brogy, you are excused, and you got your video, you got your video working.
I finally got it working just in time.
Okay.
Thank you very much.
You may be excused.
Thank you.
Okay. Additionally, we had a question before we began on taking administrative notice, and that was posed by Ms. Drake, counsel for LES. And Ms. Drake, I believe there were some specific items that you wanted me to take administrative notice of in this case. Is that correct?
Yeah, if you think it's necessary, and thank you for the clarification. I've had different hearing examiners approach this in different ways. So just for certainty for everyone, I appreciate the clarification that if we're simply going to cite to these materials in post-hearing legal briefs, that we don't need you to take express administrative notice of them in the hearing.
And yes, and that was a question that was posed before we went on the record, whether or not that it was my practice, if in legal briefing someone wanted to refer to another commission case, whether or not they had to have made at the hearing a request for administrative notice. My answer is no. If it's a commission record, it's a commission record, and if the parties want to cite to it, they can. To me, taking administrative notice of a particular case during the hearing simply highlights it or gives me some kind of, if I am not able to tell from the questioning or from the testimony, it simply provides me an opportunity to get some advance notice that, hey, somebody thinks this other commission case is important, and so more of a highlighting mechanism.
Thank you, appreciate it.
So with that, Ms. Drake, do you want me to take administrative notice of any specific case or no?
I think for clarity and convenience, it would be helpful just to get it out of the way, I guess.
Okay.
We had marked and provided notice on several, I believe 6 items from case number 17-00044-UT. If you would like, I can list those for you.
I'm happy to take administrative notice of 17-00044.
That's very helpful. Thank you very much.
Okay. I'm assuming there's no objection to me taking administrative notice of that case. And as a former SPS Hale and Sagamore case, hearing nothing. So I've taken administrative notice of that. I don't recall, Ms. Lees, did you have a procedural matter or no?
Just exhibits to admit once we get started.
Okay, and let's just do it. Let's just take the question was, some of the witnesses have been waived because inefficiency, for an efficiency purpose, that no one had questions for them. And to those witnesses, your testimony is important. So please don't feel slighted if no one had questions. But what I would like to have done as we go along and each party gets the opportunity to present their witness, they can offer up the testimony of the witness who's been waived. Okay. So if there's nothing else procedural that we need to take care of.
Two quick things. I
Yes, Ms.
also have I wasn't sure how we were going to handle prior orders or documents from prior cases. So on OPL's exhibit list, we do have the recommended decision from case number 1583, which is where the Roswell and Chavez PPAs were originally approved. I was planning to just request to admit that as an exhibit. But given what Ms. Drake just did, I wanted to make you aware of that. I am going to probably ask Ms. Sakia some questions about it, so I'm happy to admit it at that time or whatever you would prefer.
I would prefer that we have our exhibit, our exhibits to the hearing as lean as we can, Ms. Coleman, I'm happy to take administrative notice of case number 15-00083. In this case, and I really don't find the necessity of admitting it as an exhibit. Any objection to me taking administrative notice of case number 15-00083? Hearing no objection, I will take administrative notice of that, Ms. Coleman.
Thank you. And one other item, I just wanted to clarify, Mr. McMillan, who put in an appearance from our office, he is not licensed in New Mexico and did not enter a Pro Hoc Vice request. So I wanted to clarify that he is not going to be conducting any cross or anything like that. He's listening to help with exhibits and briefing. So I just wanted to clarify that.
Okay. Very, very well. Okay. Any other procedural matters that we need to deal with?
Madam Hearing Examiner, I just had a question. Do you want our witnesses who have been waived in terms of cross-exam, do you still want them to appear to enter their testimony? Or can we assume that they're excused?
No, ma'am, but by waiving them, my understanding is that you all have an agreement that no one is going to contest that this is in fact the testimony, the true and correct testimony of the witness. And as I indicated in the pre-hearing on Monday, as long as it is the correct version and you're not going to try to change anything when you offer it, and there's been a verification attached to that testimony, then there's no necessity to have your witness appear.
That's great. Thank you, ma'am.
Okay. Anything further? Nope. All right. Well, let's go ahead then and begin the evidentiary portion of our hearing. So, Ms. Lees,
Yes.
if you would like to go ahead and begin your presentation, please.
Thank you. Before I call our first witness, Mr. Elsey, to the stand, I'd like to request that two exhibits get entered. The first is SPS Exhibit 1, the application and proposed notice filed in this case. The second is Exhibit 3, the direct testimony and attachments of Richard M. Luth on behalf of Southwestern Public Service Company, which was also filed in this case on July 1st.
All right. Is there any objection to the introduction of SPS Exhibit 1, the application and proposed notice? Ms. Lees, does that also include the annual report? Or is that Ms. Sakia's testimony?
I believe it's attached to Ms. Sakia's testimony.
Okay, very well. So SPS Exhibit 1, application and proposed notice. Hearing no objection, SPS Exhibit 1 is admitted. Okay, and then you also have the direct testimony of and attachments of Richard M. Luth, SPS Exhibit 3, and the in both of these instances, Ms. Lees, the PDFs that you sent pursuant to my pre-hearing memorandum order, is that in fact or are those in fact the exhibits that you want to introduce in this case? Okay,
Yes, they
very
are.
well. And the Exhibit 3, the direct testimony and attachments of Mr. Luth, those contained a verification, correct?
I believe they do. Let me just double check right now. Yes, they do.
Okay, very well. Any objection to what's been identified as SPS Exhibit 3, the direct testimony and attachments of Richard M. Luth? Hearing no objection, SPS 3 is admitted. Ms. Lees.
Thank you, Your Honor. SPS at this time will call its first witness, Mr. Ben Elsey, to the stand. And I'll start questioning him after he is sworn in.
Mr. Elsey, can you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And just for the record, per agreement of the parties, there was an agreement that allowed for remote swearing of the witness by the court reporter, and without the necessity to have a notary public there to verify the identity of the witness. And with that, go ahead, Ms. Lees.
Thank you, Madam Hearing Examiner. Mr. Elsey, can you please open up a document that I've marked as Exhibit 2, SPS Exhibit 2?
I have it open.
Okay. Can you please identify that document?
This is my direct testimony in this case.
Thank you. And was this document prepared by you or under your supervision and control?
Yes, it was.
And if I were to ask you the same questions today as are in this direct testimony, would the answers be the same?
Yes, they would.
Do you have any corrections to this testimony?
No, I do not.
Okay. With that, Madam Hearing Examiner, I move for the admission of SPS Exhibit 2, the direct testimony of Ben R. Elsey.
Any objection to what has been offered as SPS Exhibit 2, the direct testimony and attachments of Ben R. Elsey? Hearing no objection, SPS 2 is admitted.
Thank you, Madam Hearing Examiner. With that, I pass the witness.
And I believe that in its pre-hearing memo, SPS indicated a proposed order of cross-examination. Is that correct?
Yes, Your Honor. However, I believe none of the parties had any cross for Mr. Elsey. I could be wrong.
Okay.
I believe they did.
Okay. Now, well, first I'm just getting to the point that, that you have this proposed order of examination. Was that SPS's or was that an agreed upon proposed order?
That was agreed upon, Your Honor. SPS with the parties.
Okay, because I'll just note for the record that I don't believe it's in the, normally the way that I do cross-examination is it's always the company that goes first. And then after that, it's by order of intervention. And I don't know that this is by order of intervention, is it?
I don't know that it is. My apologies, Your Honor. I thought you wanted us to come up with the order of
And you can. Again, I'm all for, to the extent the parties can reach an agreement, especially in a short time frame case, that's fine. Again, just saying for the record that this is a variance from what I normally would allow. And so no one had questions except for me. Well, sir, I don't have many for you, but I did want to get some clarification on your testimony. And my understanding of your testimony. And I think I understand the first part of your testimony where you're talking about the planning process. And I guess I had, main thing I had questions about, if you would turn to page 15 of your testimony and you're posed, well, I think it's kind of a follow-up to the question on page 14 about SPS's recommendation in the case. And you're talking about a request to acquire additional RECs, correct?
That is correct.
And on the next page, page 15, the question that's posed at lines 1 and 2, if SPS is projected to be compliant through 2026 without acquiring these additional RECs, why is SPS requesting approval to acquire them? And then you answer basically from line 3 through 17 of that page, and then lines 1 through 5 of the next page. And you say at lines 7 through 9, securing low-cost, long-term compliance with the RPS standard today allows SPS flexibility in the future to pursue the most optimal and cost-effective renewable resources, correct?
That is correct, yes.
And I'm just wondering if in viewing that, I mean, I understand having enough having enough RECs for compliance in the near term and even perhaps after the near term is important. But I'm wondering if you believe that there gets to be a time where you've got so many RECs that are banked that it's not a bit of overkill, that basically the customers, the SPS customers are having to plan or having to pay for SPS's RECs, for 10 years or 20 years, if that doesn't become an issue.
Sure. So the reason I'm supporting the purchase of these additional RECs is our next step up in REC requirement that is in 2025, when the requirement increases to 40%. If we do not purchase these RECs today to extend our bank position, we will need to acquire additional renewable energy in the mid-20s. Right now, as I state later in my testimony, there is a backlog in acquiring interconnection rights for new renewable generation. If we can get interconnection rights, it's likely that they would be extremely expensive to build the transmission that's required. So what I'm suggesting now is we purchase these RECs today to give ourselves the flexibility to acquire renewable generation when it's at its most cost effective in the future. So while I understand where you're coming from, I believe that if we were to acquire RECs today, we could build ourselves in a good banked position to see us through to the late 20s and the early 30s.
But don't you already have a significant number of banked RECs right now?
We have enough bank recs right now to comply through 2026 using a conservative load forecast. If we had an increase in load, we may only get through to 2025. In the purchase of new renewable energy right now, with the interconnection problems, would be 2025 would probably be the earliest we could get additional generation online.
Do you think that having a significant amount of banked RECs could somehow make SPS too secure to rely upon those and actually act as a disincentive to acquiring new renewable resources because you know you have your bank account, your banked RECs to assure compliance?
No, personally, I do not believe that. There's a couple of reasons why. First of all, if you look at the quantity of existing generation that is due to retire in the next 10 years or so, we have to acquire new generation regardless of the RPS requirement. We also have 2 significantly sized coal units that are due to retire in the next 10 to 20 years. So regardless of the RPS requirement, SPS are going to have to acquire new generation. All of our indications show and trends show that renewable energy is becoming more and more economical year on year. And I just think this gives us the time to make those decisions at the right point in the future, as opposed to being forced to make them now to comply with an RPS requirement.
And I had one more question about the banking too. Mr. Elsey, have you participated in rate cases?
Not as a witness.
For a utility? Okay, but you're familiar with the principles of rate making in a rate case for a public utility?
At a fundamental level, yes.
Well, my understanding that I've heard about over the years for rate cases is one of the principles that in setting rates that that public utility commissions look at has to do with a matching principle that the customers that the utility has that they currently have are the ones that are paying for the services. So this matching principle of not having, the current customers, pay for something in the future, or necessarily for something in the past that's not providing service. We look at that, and I'm just wondering if we have all these bank-to-HUD RECs that aren't going to be used into the future, whether or not we're going to violate potentially that matching principle of having a mismatch of customers paying for something now that they're not getting any benefit for. Any thoughts on that?
Madam and here, Examiner, would probably getting outside my area of expertise, and I would kindly ask to defer that to Ruth Sakia, if that's okay.
Okay, very, very well, sir. And I do note on my question about being having a big bank of future RECs being a disincentive, you do go on at page 18 of your testimony and testify with regard to that. And then I guess briefly, on page 19 of your testimony. The question posed at lines 4 and 5, could SPS's New Mexico retail sales be greater than SPS projected in this case? And then you answer from lines 6 to 16, you're saying yes. And I'm wondering the basis for some of your statements, like the statement at line 9. Recently, SPS has experienced significant oil and gas load growth in the Southeast New Mexico. However, COVID-19 and the collapse of oil prices have disrupted that growth. Do you have any specifics that you relied upon, to support your next statement that says I used SPS's COVID-19 load forecast in my projections, which includes only a moderate amount of future oil and gas growth?
Yes, and I do not have the numbers with me, but as a general process, the company releases 2 load forecasts on an annual basis in the spring and in the summer. This year, we actually introduced a 3rd load forecast that was shortly after the pandemic that included our projected load growth over the short and longer term. I relied upon this forecast when creating my projections. Part of the reason for taking this conservative approach was to ensure that we didn't have too many bank wrecks. So in my feeling and kind of in my testimony is the likely event is our load forecast is actually going to be higher than I've included in my projections. So I feel like I've produced a conservative approach when in reality load forecast and our rec requirement will actually be greater than is included in my testimony.
So then if I'm understanding you, you're saying that COVID has not affected that load growth?
No, excuse me. No, COVID absolutely has had a detrimental effect on our load growth, both in the short term, directly for the COVID impact, which was anticipated to be 2020 and 2021. And then on a longer term in planning horizon, it's all down to the recovery in the oil and gas market. If there's a fast recovery from the COVID and the collapse of oil prices, I expect there to be higher load forecast or higher load increases than are included in the forecast.
Higher load than was originally projected, or higher load than the disrupted forecast?
Higher than the disrupted forecast and more in line with the forecast we've included in previous years in previous filings.
Okay. And even though there's been the disrupted growth in the oil and gas load growth, has there been a residential increase?
Again, unfortunately, I don't have the numbers in front of me. There has been a small residential increase from my recollection. But going forward, SPS are predominantly a commercial industrial serving entity. So I would say on a longer term planning horizon, that increase in residential growth would not offset any detrimental growth in the oil and gas industries.
And is your testimony just based on SPS's service here in New Mexico, or are you talking company-wide?
It's based on a company-wide load forecast that is then tailored just to the New Mexico allocation.
Okay, very well. Thank you, sir. That's all the questions that I had for you. Ms. Lees, any redirect for Mr. Elsey?
No to redirect, Your Honor.
Okay. Do any of, no one had any questions of him before? Does anyone have questions based on my questions?
Madam Hearing Examiner, I just have
Mr.
one,
Bagatko.
if you'll permit me. Thank you. Mr. Elsey, You mentioned a couple of coal plants that'll be retiring in about 20 years or so, if I recollect correctly. Does that meet with your recollection?
I believe I said 10 to 20 years, but yes.
Okay, and I think I know which ones you're talking about, but for the record and clarity, could you identify those two coal plants, please?
Sure, we have Toke Station and Harrington Station.
Thank you very much, Mr. Elsey. That's all I've got, Madam Hearing Examiner. Thank you.
Thank you. Anything further from any other party?
Yes,
Ms.
ma'am.
Drake?
Thank you. I just had a question following up on the hearing examiner's question about load growth disrupted by the COVID virus. And I think, Mr. Elsey, if I heard correctly, your testimony is that you think you took a conservative approach and that load will be higher, more in line with your previous pre-COVID forecasts. Is that right?
Yes, that's correct.
And about when do you see that, especially I'm thinking about the oil and gas load, but I know that residential load may follow along with that as folks start going back to work. But about when do you foresee that load growth getting back to the more, what we think of as normal pre-virus levels? About what time frame?
Honestly, I do not have a good estimate for that right now. You know, there's lots of economical factors that will affect oil and gas growth over the next decade, and I do not know the answer.
All right, thank you.
Very well.
Examiner, I just have a clarifying question based on Ms. Drake's questioning of Mr. Elsey.
Okay.
Mr. Elsey, I just want to clarify that when you say you anticipate the load going back to previous forecasts, more in line with previous forecasts from the COVID-19 forecast that we presented in this case, that is dependent on when the oil and gas industry starts to rebound, correct?
That is correct, yes.
Okay.
Very well. Anyone have anything further for Mr. Elsey? Hearing nothing. Thank you, sir. You are excused.
Thank you.
Ms. Lees, you have another witness.
I do, Your Honor. SPS calls Ms. Ruth Sakia to the stand.
Good morning, Ms. Sakia.
Good morning, Madam Hearing Examiner.
Melissa, if we could swear the witness, please.
Yes, ma'am. Can you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Very well. Ms. Lees.
Yep. Thank you, Ms. Sakia. Can you state your name for the record?
Ruth M. Sakia.
And can you please open up what I've marked as SPS Exhibit 4 and SPS Exhibit 5?
Give me just one moment, please. Okay, I have SPS Exhibit number 4. And SPS Exhibit number 5.
We'll start with SPS Exhibit number 4. Can you please identify this document for the record?
SPS Exhibit number 4 is my direct testimony filed on behalf of SPS on July 1st, 2020.
Okay. And was this document drafted by you or under your direct supervision and control?
It was.
And if I were to ask you the same questions today that are in this document, would the answers be the same?
They would.
And do you have any corrections to this document?
I do not.
And are the answers true and correct to the best of your knowledge?
They are.
Okay. And going to Exhibit number 5, can you please identify this exhibit for the record?
This is my rebuttal testimony filed on October 2nd, 2020.
Okay. And was this document created by you or under your direct supervision and control?
It was.
And if I were to ask you the same questions today that are contained within this document, would your answers be the same?
They would.
And are those answers true and correct to the best of your knowledge?
They are.
And do you have any corrections to this document?
I do not.
With that, Madam Hearing Examiner, SPS moves the admission of Exhibit 4 and SPS Exhibit 4 and SPS Exhibit 5 into the record.
Ms. Sakia, is the annual report part of your testimony?
It is. It is attachment 2 to my direct testimony.
That's what happens when you make your own notebook. You get things.
I truly understand.
I
was
Mr. Luth.
I was lamenting the same thing.
Attachment 2 to your direct?
Yes, attachment RMS-2 to my direct testimony.
Okay, very well. Any objection to what's been identified as Ms. Sakia's direct testimony as verified by her here today, and Ms. Lee's SPS Exhibits 4 and 5 were the exhibits that you submitted pursuant to the pre-hearing memorandum order last week, correct?
Correct, Your Honor.
Very well. Any objection to SPS Exhibit 4? Hearing none, SPS Exhibit 4 is admitted. Any objection to what's been identified as SPS Exhibit 5, the rebuttal testimony and attachments of Ruth M. Sakia as verified by Ms. Sakia here today? Hearing no objection, SPS Exhibit 5 is admitted. Ms. Lees?
I pass the witness, Your Honor.
Very well. Well, we'll go with your order. And Mr. Lundin, any questions for Ms. Sakia?
Your Honor, I have no questions at this time. Thank you.
Very well. Ms. Coleman, any questions for Ms. Sakia?
Yes, Your Honor.
Go ahead, please.
Thank you. Good morning, Ms. Sakia.
Good morning, Ms. Coleman.
I am going to reference you. I hope you got the exhibits that we circulated. I'm going to reference a couple of them. So if you
I
could
believe so. I'm sorry, give me just one moment. Let me make sure that I can get to them and that we have the same ones.
There should be 7 total.
Okay, I have 7 exhibits.
Okay. So the first thing I'm going to reference besides your rebuttal is it's marked OPL Exhibit 6.
Okay.
And this is the recommended decision from docket 1583. I am not going to request to admit that as an exhibit because the hearing examiner took administrative notice of that docket earlier. But you are familiar with that case, correct?
I am.
Okay. So I want to ask you a question. On page 7 of your rebuttal, you are addressing the statutory standards for evaluating a proposed RPS procurement. Is that correct?
I am.
Okay. And one of the points that you make is that the Roswell and Chavez PPAs were the result of a competitive procurement under Factor A that you've identified. Is that correct?
Correct.
Okay. And is it correct that the Roswell and Chavez PPAs were procured under an RFP that was issued in September of 2014? Do you recall that?
That sounds about right. Yes.
Okay. And is it also your recollection that responses to that RFP had to be submitted roughly a month later in October 2014?
That also sounds correct.
Okay. And is it also your recollection that that RFP was limited to solar generation resources with a COD no later than December 2016.
That also sounds correct.
Okay, and to your recollection, did you receive any bids other than the NextEra PPAs in response to that RFP?
Hang on just 1 second. I have a noise issue. I need to fix it.
Of course, Your Honor. You're muted.
Here we go. Don't get visitors very often here in the country. Dogs don't know how to act. All right, thank you. I'm sorry, Ms. Coleman, go ahead.
No problem. Okay, I think, Ms. Sakia, the last question that I had asked you is, to your recollection, did you receive any bids other than the NextEra PPAs in that 2014 RFP?
I actually can't recall, Ms. Coleman, but that would not surprise me.
That they were the only ones? Okay.
Correct.
Okay, and just, I think this is obvious from the RD, but just to clarify, at that time, the resources were being sought based on their purported cost savings and not for RPS purposes. Is that correct?
Correct.
Okay. If you could open up exhibit, what's been marked OPL Exhibit 7.
Give me just one moment. Okay, I have that exhibit.
Okay, and oh, go ahead.
Let me just make sure that I have the correct one. At the top left, it is labeled EIA, and then it has a chart or several charts, including solar, voltaic, onshore wind, and then natural gas.
That's correct.
Okay.
And so to that point, you're familiar with the EIA, is that correct?
I am.
And you're familiar that that's a government entity that issues cost information on generation technologies?
I am.
Okay, and looking at OPL Exhibit 7, and I'm looking at the solar photovoltaic chart that's at the top right. Do you see that?
I do see that.
Okay, and would you agree with me that looking at this chart, it indicates that the cost of solar has declined significantly since 2014? Would you agree with that?
I would agree that between the years 2013 and 2018, that the cost of solar photovoltaic have decreased.
Okay, thank you. And Your Honor, I would offer OPL Exhibit 7 at this time.
Ms. Coleman, what is this? I mean, is it a report? Is it
yes.
A web page? What is this document?
Yes, Your Honor, that's what I was trying to cover with Ms. Sakia, but it is a U.S. Government agency that issues cost information on generation technologies, and this is an analysis that they provided of various technologies over the 2013 to 2018 time period.
Ms. Sakia, do you look at the reports from this agency?
I do a little bit. Mr. Elsey has more familiarity than I do.
But But you don't question that, you know, that this is a government agency and that they put out this kind of information?
I do not.
Is there any objection to OPL Exhibit 7, the EIA U.S. Energy Information Administration average U.S. construction costs for solar and wind generation continue to fall exhibit? Hearing no objection, OPL Exhibit 7 is admitted. Go ahead, Ms. Coleman.
Thank you, Your Honor. And then, Ms. Sakia, I wanted to reference you back to the RD from case 1583, if you have that handy, and I'm looking at page 45.
Page 45, hold on just one moment.
It's 47 of the PFD, but 45 internal pagination.
Page 47 at the bottom of the PDF.
Page 45 at the bottom.
Oops, just one moment, I was at the wrong one. Okay, I believe I'm there. So at the bottom right-hand corner, it says page 45. And the footnote at the bottom would be like 164?
Yes.
Okay.
And my question relates to the top full paragraph. Do you recall that under the economic analysis for Roswell and Chavez, the break-even gas price was $5.42 an MMBTU?
Yes, that is what is noted here in the recommended decision.
And to your knowledge, have gas prices generally been above or below that level since 2014?
I can't speak since 2014. I can say right now, gas prices for the delivered to the SPS system are below $5.42.
Okay, thank you.
How much below? Ms. Sakia?
Right now, I think they would be closer to, say, $2 per MMBTU. Now, how that compares on a 25-year levelized basis, I couldn't speak, but currently I would say closer to, say, $2.
Okay, thank you. Go ahead, Ms. Coleman.
Now looking at page 11 of your rebuttal testimony.
Give me just 1 minute. And then page 11 of the bottom, and that's like page 16 of the PDF.
Yes.
Okay.
Are you there?
I am.
Okay. And here you are representing that the cost of the Roswell and Chavez PPAs is $15.40 a megawatt hour. Is that correct?
The effective cost, yes.
Okay, and that effective cost is what you're using to compare it to some of these other resources, correct?
It is, yes.
And by effective cost, you are referring to the cost per megawatt hour after you apply your proposed capacity credit. Is that correct?
That is correct.
Okay, and if I understand your capacity credit correctly, that is essentially assigning 80 megawatts of capacity to the New Mexico retail jurisdiction for production plant allocation purposes between the Texas and New Mexico jurisdictions. Is that fair?
Yes, so that would happen in a base rate case.
Okay, and I believe you can check this on page 13 of your testimony, but you estimate that capacity credit is being worth $23.19 per megawatt hour. Is that right?
It is.
Okay, and so if you add that $15.40 that you're citing on page 7 to that capacity value, is it true that the total cost of the PPAs today would be approximately $38.59 a megawatt hour?
It is.
Okay. And do you recall that under the PPA terms, that price actually escalates by 2% each contract year over the life of the PPA?
It does have a contract escalator, yes.
Okay, and so would you agree that unless the capacity credit also escalates, the cost to customers would increase annually over time from this $15.40 that you're citing?
Yes, it would.
Okay. And just looking back at the recommended decision, which you're welcome to do or subject to check, is it your recollection that the levelized prices for the facilities were $41.55 a megawatt hour for Roswell and $42.08 for Chavez? Does that sound correct?
That does sound right.
Okay. So under your proposal, am I correct in understanding that essentially the full PPA price per megawatt hour would be charged to customers on an energy basis as soon as this allocation is approved, if it's approved? Is that correct?
Correct.
Okay, and then in some future rate case, you all would propose a capacity credit that would partially offset those costs. Is that correct?
Correct. I apologize.
Okay. Oh, go ahead. Did you finish?
So we have the capacity credit, and then as I also talk about later, there are some energy savings and sales credits that would also be applied.
Okay, so until that credit is provided, though, New Mexico customers would be paying just the full PPA price.
Correct. Although the commission could delay or sync up as Mr. Higgins proposed, such that this proposal would start at the same time as the capacity credit, and then they would match exactly.
Do you happen to know when you're proposing to file your next base rate case?
Approximately January.
January 2021?
Yes.
Okay. Is it correct that SPS's production capacity costs are not allocated on an energy basis, but rather on a production demand basis?
They are, yes.
Okay, and so is it your understanding that the value of that capacity credit that you're proposing would not be the same for all customers or for all customer classes?
That is true.
And so the average might be that all customers are paying $15.40 a megawatt hour, but individual customers or customer classes might be paying more or less than that due to the percentage of the capacity credit that they actually receive. Is that fair?
I think so, yes.
Okay. And you're familiar with the concept of imputed capacity, I assume?
Yes.
Okay, and is it your understanding that when you have a imputed capacity associated with the PPA, that essentially the way it works is the capacity value of the PPA is removed and charged to customers on a production demand basis, and then the remainder of the PPA cost is allocated to them based on energy? Is that generally correct?
I haven't actually seen it done, but that sounds like a way that you could do it, in the way it probably has been done. But it's probably a little beyond anything I could exactly speak to.
Okay. Let's see. Earlier, did you hear the conversation between Mr. Am I going to say this right? Elsie, and hearing examiner Hurst indicating that currently you have enough banked RECs to comply with the ETA through 2025. Is that correct?
Yes.
Okay, and now I would like to reference you to what's been pre-marked OPL Exhibit 3.
Exhibit 3. Okay.
Okay, and do you recognize that as SPS's response to OPL RFI 3-2?
I do.
Okay, and is this an RFI response that you sponsored?
It is.
And here you were asked whether the proposal to assign the Roswell and Chavez PPAs to New Mexico customers is time sensitive. Is that correct?
I was.
And you acknowledged that the assignment could be done at another time, essentially unless SPS finds somebody else to sell it to. Is that correct?
That is.
And Your Honor, Oxy would offer OPL Exhibit 3 at this time.
And what is an RFI?
I'm sorry, it's a discovery request for information.
Okay. Like, is that an interrogatory?
Yes.
Okay. Okay. And your exhibit consists of one page?
Yes, ma'am.
Any objection? And it says that Ms. Sakia was the person who responded to this. Is that right, Ms. Sakia?
It is.
Okay. Any objection to what's been identified as OPL Exhibit 3, the RFI, OPL 3-2, and the response? Hearing no objection, OPL Exhibit 3 is admitted. Ms. Coleman?
Thank you. Ms. Sakia, I forgot to ask one question. Back to our discussion about customers being charged the full PPA price and then receiving a capacity credit in the next base rate case. I understand that the New Mexico Large Customer Group has some proposals around that. Would SPS be willing to instead just charge all customers the $15.40 per megawatt hour price that you quote and eliminate the capacity credit aspect of the proposal?
I've actually not thought about that. I would need to take that back, or at least have a little time to think about that. So if you would give us some time, we could think about that.
Ms. Coleman, why would they do that? What would be the benefit of doing that? Why are you proposing that?
Subject to an objection about testifying.
Yeah.
The reason that we would be interested in that as a positional matter is because there's a mismatch in how the PPA costs would be allocated on an energy basis, and then how the capacity credit would be allocated, which is on a production demand basis. So that mismatch creates winners and losers among the different customers and customer classes, such that the effective price for all customers would not be $15.40.
Okay, so OPL's disputing Ms. Sakia's testimony that about the effective energy price on page 11 of a rebuttal.
I think as we were just discussing, I think that her testimony is correct on average for all customers, but as to individual customers, it may not be.
Okay, and I wanted to, that 1540, that's just the energy price, isn't it, Ms. Sakia? That doesn't include you're buying the RECs.
Correct. That does not include buying the RECs.
So do you know how much more, how if you added the RECs that you're going to buy into this price, how much it would be?
If you give me just a moment, at the back of my direct testimony, I had REC prices, and I have so many pages of my attachments, but give me just a moment there. And let me find the right attachment for you. If you would, Madam Hearing Examiner, if you wouldn't mind, maybe if we take just a minute or two at a break, or I know I have it, I just have 200 pages of testimony and I am not flipping to it really quickly, but I could get that exact number of what it would add.
You do have a lot of testimony. I'm not used to seeing this much testimony from you.
Generally speaking, we put a lot of this on CDs and put it electronically, but because of COVID and we didn't know how to serve everybody so that they would have access to it, we printed it out and it made my testimony much longer than usual.
Yeah, and you know these computers that they gave us, I got mine replaced, I think after like 5 years. It doesn't have a CD drive.
Yes, exactly. And
So
some people have
back
jump
in the office, we had one external drive that we were sharing. So I don't know what happened to it in the eviction, but I can tell you Elizabeth did not get it. So I'm kind of glad. I'm sad for the trees. And I could be wrong if it's your is it your work paper? Is it your attachment 8?
It might be.
It might be attachment 5, Ruth, the annual rec prices and estimated cost of proposed rec acquisitions.
Okay, that does sound right. Thank you.
It's attachment 5 to your direct.
There we go. Thank you, Ms. Lees. Yeah, so attachment 5, Roswell and Chavez, it lists the rec prices per year. So starting, for example, in 2021, the Roswell and Chavez recs are 54 cents per megawatt hour.
Okay. So that would make it $15.94 then.
Correct, with the rec.
Okay. Thank you. Go ahead, Ms. Coleman.
Thank you, Your Honor.
Oh, let me ask one more thing before we get away from that, so I won't forget. You talked about when Ms. Coleman was asking you about what credits might actually be applied. And you said there were credits other than the capacity credit, correct?
There are, yes.
And those were retail. Tell me what those other credits were again.
Okay, and those it might be useful when we get to New Mexico Large Customer Group. They have a couple of exhibits that I prepared in response to their discovery that might be useful for us to look at in describing them. But there will be some offsets through the fuel adjustment clause. 1, an energy offset, and 2, when we make sales into the market, 100% of those sales go back to New Mexico retail customers. And then in additional, there will be some market revenues from the SPP that will also go through and be a credit to our customers.
And those would not be applied until, if SPS proposal was approved, they wouldn't be applied to until the future, right?
Those would be applied actually as soon as this goes into effect because they would go through the fuel adjustment clause.
Okay. Very well. Go ahead, Ms. Coleman. Thank you, Ms. Sakia.
And I'll ask one follow-up question on that issue. I assume you're referencing the revenues that customers would get if these resources were sold into the wholesale market for a price that exceeds the PPA price. Is that correct?
Can you ask your question again? I want to make sure that I was following you.
When you reference a credit that customers might receive in fuel, that would essentially be if the output of these resources were able to be sold at a profit in the SPP market. Is that correct?
The way the economic dispatch will work, it's actually not related to a price greater than this PPA. It's based on our economic dispatch and the entire system. And so it will be whether or not the way, for lack of better words, the New Mexico system will be dispatched and whether or not we can sell the system at the top of our stack into the market. And so it won't be related per se to this resource anymore, but to the entire stack of resources allocated to the New Mexico retail system.
But it would presume on the whole that you are making a profit relative to your actual costs.
Correct, on an incremental basis, yes.
Okay. And your capacity credit allocation proposal, and I think we touched on this earlier, but that's essentially a proposal to make an adjustment to the jurisdictional capacity allocation between Texas and New Mexico. Is that correct?
It is. Now that Texas has declined to take any of this, it would be appropriate if New Mexico takes this capacity to give them the credit for the capacity.
And is it your understanding that each state regulatory commission approves those jurisdictional allocations in your rate cases?
It is, yes.
And so that would have to be something that Texas would also approve of?
We will have to go to each state commission. So New Mexico will approve New Mexico's retail allocation. Texas will have to do what they do in a rate case with their allocation factor.
And is it possible that Texas and New Mexico could approve different retail allocations?
Absolutely.
And in that instance, if Texas approved an allocation that did not recognize this capacity credit, would you commit that SPS would not propose to change this prospectively for New Mexico retail?
I don't know what the company would do, but I can tell you that we think this is a fair and reasonable proposal for New Mexico customers, and our intent is not to come and harm or try to create a detriment for our customers.
Okay. I'm going to move on now to, this is pre-marked exhibit OPL exhibit 4.
Okay, and it's titled question number OPL 3-3, and this would be another response that I provided in discovery, correct?
Yes, and so that was going to be my next question. So do you recognize this as a response to an OPL interrogatory that you sponsored?
It is.
Okay, and in this interrogatory, you are asked, is it your position that because SPS has requested an incentive in this case, the commission is required by the statute to grant some incentive? Is that correct?
Yes.
And Your Honor, we would offer OPL Exhibit 4.
Any objection to what's been identified as OPL Exhibit 4? It's hard for me to say an RFI interrogatory OPL 3-3 in the response. Hearing no objection, OPL Exhibit 4 is admitted.
Thank you. That's why I said interrogatory that time.
Thank you.
Okay, and Ms. Sakia, again, I think we just covered your position is that since SPS asked for an incentive in this case, the commission is required by statute to grant that. Is that correct?
To grant an incentive, yes.
An incentive, thank you. And you're basing that on section 62-16-4 of the ETA, is that correct? And if you need a reference, this was attached to your rebuttal as exhibit RMS-R1, and I believe the relevant section is on page 8.
Correct. 62-16-4, specifically D.
D, okay. And I was just comparing what is in this attachment to the actual statute, and I think there's a word missing here, perhaps because of this red line feature. But is it correct that the statute says, upon motion or application by a public utility, the commission shall?
Yes,
that
I have
word shall is missing here. Is that correct?
Oh, sorry, I was looking at a hard copy I have of the statute. Let me look at my attachment to my rebuttal. Somehow my electronic version does not appear to have my attachment, but Ms. Coleman, I'll take your representation, and Ms. Lees can help me correct anything that it needs to be corrected.
It's in red line, and shall is shown in strike through, but compared to the statute, I just wanted to clarify that. So your understanding of this section is that says, upon a motion or application by a public utility, the commission shall, or upon a motion or application by any other person, the commission may, and then this is what you're relying on, I assume, open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standard. Is that correct?
Correct.
Okay. Looking now at OPL Exhibit 5.
Okay, OPL Exhibit 5 would be my response to discovery titled question number OPL 3-5.
Okay, so you recognize that document and you're the sponsor?
Correct.
And in this response, you acknowledge that the commission has opened a docket to consider appropriate incentives under this section of the ETA. Is that correct?
Correct. They have opened a docket. I don't believe they have issued the actual, I think it's called a NOPR, where they publish it in the register.
Right. And I think you observed that they have had a workshop, but there's no notice of a rule yet, correct?
Correct.
Your Honor, we would offer OPL Exhibit 5.
Ms. Sakia, do you know what the case number is that you're referring to in your answer here?
I do not off the top of my head. I apologize.
Ms. Lees, please consider it a bench request. I'd like to know exactly what that case number is. Ms. Sakia, you say they haven't issued the NOPA or not, but have had a workshop, correct?
Correct.
Have participants or entities, persons, had the opportunity in this proceeding, this rulemaking proceeding, to offer comment on what should be included?
I believe so, and I'm trying to remember. Sometimes these rulemakings a little bit run together for me, but I believe there was even a joint submission, at least with the utilities, but I thought there was input from other parties about what a red line rule based on the statutory changes should look like. And then I thought there was actually some comments based on that, and then on that submittal. And I don't know that it's gone any farther than that process. That's kind of what I remember.
Do you remember whether or not the there was any comment on specifically on the financial incentive section?
It's my recollection that it basically mirrored the statutory language.
But did anybody, I mean, flesh it out to say, for example, like your proposal here, to say an incentive of, percentage points, to the ROE would be appropriate, or some other way? Was this kind of information included in that rulemaking case?
I don't believe so.
Do you know whether or not any specifics of another kind were offered?
I don't believe that there were any specific discussions about what an incentive should or should not look like, or what the process would look like. I think it was more conforming the language in the rule to the statute.
Well, don't you think it would be appropriate if this is a rulemaking on a financial incentive to include some specifics about how the financial incentive should occur?
Well, the rulemaking, I think, pending or before the commission was more general about updating the commission's Rule 572 to the ETA. I think, at least the way it currently is, it didn't address, as of yet, some of the other issues, including whether or not there should be an RPS rider, which was an issue in our last RPS case, the details of a financial incentive. I think that rulemaking is open to address those issues, but it has not yet addressed those kind of things.
Okay, I mean, because that's basically the position, isn't it, Ms. Sakia, of some of the other parties, is that there should be a consistent commission policy about how these incentives are dealt with, and that it should be in a rulemaking, correct?
Correct. And I think our position is certainly that's helpful. So, for example, the energy efficiency rule has some guidelines, but it's not required at this point.
Right. It just, I guess it just seems like to me that, if you've got this pending rulemaking, that could address financial incentives and could have it, in black and white to apply to everybody and have a standard. I guess I don't understand why that kind of information isn't being proposed in this rulemaking.
I can't speak for the commission. My thought is that that avenue is available because an official NOPR hasn't been issued yet. So there is no clock yet. The commission can still utilize its open case. So it still could use that avenue because it's still in what I would call an informal process. It still has that avenue available to it.
Right. And my point is that since this deals with money and utilities, shouldn't it be, shouldn't the onus be on the utilities to asking in this rule, hey, the statute says this, and we think the rule should include these, these XYZ things about how we get our incentive. You don't think it's your obligation?
Well, I think you could do it in a rule. You can do it in this proceeding as we have done. One of, I think, the challenges of doing it in a rule, let me step back. One of the things I think all of the parties agreed in the initial phase of the rule was we all thought Rule 572 needed to address at least the initial changes to the ETA. And we had all hoped that at least Rule 572 could address the change in requirements and some of those more perfunctory changes, and that some of the, what I would call stickier issues, could have a subsequent discussion, because I think we all know there are things we could agree on, like the rule says, or the statute says the RPS requirements changed X, Y, and Z. Those could be done rather quickly, we had hoped. And that these other issues that are more complex and that we probably aren't going to have agreement with all the parties would need to be addressed and should be addressed, but those would take more time. Our first thought really hasn't happened. That didn't get done very quickly. And so perhaps that really will now all be addressed. But that was the initial thinking, that you would address the easy things first, and then you would come back to all of these other issues.
Okay. Thank you. Ms. Coleman, anything further?
A couple things, Your Honor, yes.
Very well.
And I'm sorry, I just lost track. Did we admit OPL Exhibit
Oh, no.
5?
No, because I wanted to find out about the case and then ask the question. Any objection to what's been identified as OPL Exhibit 5? The OPL's interrogatory 3-5 and Ms. Sakia's response. Hearing no objection, OPL Exhibit 5 is admitted. Go ahead.
Thank you, Your Honor. Ms. Sakia, referencing again that open rulemaking or open project, I guess I should say, do you think that the commission could consider items like the value of additional procurements to customers in deciding whether to award an incentive, a financial incentive?
Ask that again, Ms. Coleman, please.
Do you think that in setting parameters for financial performance incentives in that rulemaking, the commission could consider something like the value that additional procurements provide to customers? Maybe let me put it another way. Do you think they could distinguish additional procurements that are at a very high cost from additional procurements that are economic in considering whether to award a financial incentive?
I don't think whether to award an incentive, no, because I don't think the statute provides that as a criteria. Perhaps, and I really haven't thought through whether it's appropriate or not, and what our position would be, whether or not that should be a criteria or not.
But you think they could consider it in perhaps the type or the size of incentive, perhaps?
Maybe.
Okay. And And so you all are proposing an ROE adder as your initial proposal, correct?
Correct.
And just going back and referencing again that subpart D of the statute, the last paragraph in that section states that the incentives may include additional earnings and capital investment opportunities for resources used in furtherance of the outcomes described in this subsection. Is that correct?
Correct.
And is it correct that your ROE adder would not just apply to RPS resources, but all of your capital investment?
It is, yes.
Okay, and so any existing or future transmission would be subject to the ROE adder.
Correct.
And any existing or new generation, whether renewable or not, would be subject to the RPS, would be subject to the ROE adder.
Yes.
Including, for example, your 2 coal plants, Tolkien, Harrington.
What's left to be depreciated, yes.
Yes. Okay, thank you, Ms. Sakia. Those are all my questions. Your Honor, I did have one thing before I pass the witness. I had asked Ms. Sakia SPS's position about agreeing to just charge all customers that $15.40 per megawatt hour. And she said that they would have to confer internally. I wondered if I could ask if they follow up with that either in a post-hearing RFI, or if you might be willing to ask it as a bench request.
I need to think about that. I mean, Ms. Lees, is there an objection to, you know, to providing a response to that?
If you request it, Your Honor, obviously SPS will do its best to provide a response. It will take some internal analysis, though. It's not something we can answer today.
I mean, Ms. Coleman, in terms of, you know, the nature of the proceeding, I don't know that we can get the information in a timely manner to do this. So, you know, to include it in the briefing, I don't know. Think about that. I think we should go ahead and take a brief recess. The computer says 10:41, so why don't we come back in about 10 minutes, and you think about this, Ms. Coleman, as far as, you know, if you think you'd be satisfied, you know, with this response. It seems like to me that, you know, the request probably could have been made earlier, you know, as some type of negotiation, but I'm willing to consider it. I just don't know how we can fit it into our proceeding. So we'll come back at in about 10 minutes. So we're going to recess for 10-minute break. Just remember, I'm not going to turn the YouTube off because we've got it on, and I don't want to break it up and have to redo it. So you know, consider that the YouTube will still be going. Okay, 10 minutes. Unmute. Okay. We're getting people back on. Ms. Zur, I liked the dog picture.
But thank you.
Madam Hearing Examiner, while we're off the record and I see Katie's here, when she was asking Ms. Saki about an attachment to her rebuttal, in going through the exhibit we sent, I realized that that attachment she asked about is not attached to the exhibit. I've had Casey Settles send around the rebuttal testimony with her attachment, and I apologize. I think that might have led to some confusion. Is it okay if we enter the correct exhibit with that attachment to it? And how would you like to deal with that?
Okay, so you're saying that that attachment RMSR1 is not the correct attachment?
No, it's in exhibit 5, it just looks like it was inadvertently omitted. The attachment wasn't included in that exhibit. And I thought it had been, and that is my fault, my apologies.
Okay, so you're saying that the PDF you sent around doesn't conform with the written testimony that was filed?
No, what the exhibit that was sent around to the parties just didn't include the attachment that was filed in the docket with that rebuttal, which Ms. did ask Ms. Saki about.
Okay, because in my copy of Ms. Sakia's rebuttal testimony, I have an attachment. I have
Okay.
R-R1.
Okay, as long as you have it and that's the official version, it just.
Oh, no, I'm just saying for clarity purposes, but what Ms. Coleman appears to have pointed out is that the attachment's not correct.
The attachment is the redlined version of the legislation that the legislature put out. It's
So you're saying it is a correct representation then?
it's not a representation of what the statute says. It's a representation of the red line that the legislature did in passing this bill. So it encompasses a lot of iterations.
Okay.
Anyway, my concern was that it wasn't attached to the version that had been sent out. And I want to confirm that it was attached to Ms. Sakia's rebuttal testimony that was sent out to the parties.
Okay. If
Because
your
it seemed
exhibit
like when Ms. Sakia was looking for it, she couldn't find it. So my concern is that I want to make sure everyone got the rebuttal testimony with that attachment.
Okay.
And I've had Mr. Settles with SPS resend it just to ensure that the parties have the rebuttal exhibit with the attachment included.
Okay, and I'll check. I mean, obviously the package that we have prepared to give the court reporter is the one that has to be accurate.
Yes. So that's what I'm trying to make sure that it.
Right, and that I will check over the lunch hour and get back to you.
Okay, and if we need to do anything on the record just to correct that, let me know.
Okay. Mr., what was the pup's name?
Really, for all of YouTube? It's,
if you don't want to, that's okay.
It's Chili Jude.
Okay, cute. Just for those who aren't seeing the screen, people have their still pictures, and that's a pup picture. So we can go back on the record now from our break. We've had a conversation with regard to potentially not having the correct exhibit, which I'll check over the lunch hour and make sure we're that we have that. Ms. Sakia, did, as part of your testimony, the exhibit that we're talking about, this RMS-1, obviously, since it's an attachment to your testimony, I'm assuming that you intended to have this representation of the statute is the one that you wanted, correct?
Correct.
As opposed to the final version of the statute.
Well, I intended it to be the red line, but the correct red line to represent the changes that showed the final version. Am I making any kind of sense?
Well, I'm just wondering if it is, it's your exhibit, so, you know, not trying to say anything about your exhibit. It just seems to me by the tenor of Ms. Coleman's questions that that there was some doubt about whether or not it was actually the final version of what got passed, but.
Your Honor, if it would help for me to clarify, my understanding of what happened is that Ms. Sakia attached an official red line that the legislature prepared, but that red line was missing a word relative to the final adopted language. So I think it's a true and correct copy of what the legislature issued as a red line. It just, due to a software error on their side, didn't match the final language.
Okay, and that was what my understanding was. And again, Ms. Sakia, it's your exhibit, and you know, if you want your exhibit, if your intent was that it was this red line version, and that's what you wanted to represent rather than the actual final statute, then that's okay. But if that's not what you wanted, then I need to hear from you.
Okay. Well, in theory, I thought it was, I thought that the red line version would match what the words to the, when you accepted all red lines, it would match the other printout that I had, and that the words would match. And so I didn't obviously read it as closely as I thought I had. And so when Ms. Coleman and I were discussing the words that she read, that's exactly my understanding. So I think something happened in the translation.
Okay.
And the red line was only intended to show the changes made, you know, during the ETA amendments to the REA.
Okay. Very well. Now, on this, before we went to recess, Ms. Coleman had asked Ms. Sakia about whether or not SPS would consider doing something differently with regard to the application. I believe of the effective price for Roswell Chavez. And Ms. Lees, you indicated that if I ordered it, you would endeavor to come up with a response. And again, I'm just trying to figure out in the context of this case, how we could accomplish this. And Ms. Coleman or Ms. Lees, any thoughts on this?
Your Honor, I would just say that honestly, I expected the answer to that question to be no, because what I'm suggesting is a lot simpler than what they proposed. So I figured if they were open to that, they would have proposed that in the first place. But to the extent that they are open to it, you know, if we could get that response just even a couple days before the initial post-hearing brief is due, that would be sufficient. I think otherwise, all I'm going to be able to say is they weren't able to commit to that. If they were, that, in my view, would be a better alternative. And so, I think that's probably what we would say, without having conferred internally also. But that's kind of how I see it.
And I guess, I don't know what position that would put the rest of the parties in. If there's some kind of, deal making going on between the two parties, then, it might benefit OPL, but it might not benefit someone else in the case. And then what are they going to say? So, to the extent, this would be, new evidence, then we'd have to build in, the opportunity for other people to respond to this. So, I'm not real comfortable with that at this point. And I think, unless during the luncheon hour, SPS can get a response to this, so that the other parties would have an opportunity to, to ask about this, or to say, what about me? How might it affect me and my client? I really don't think we can do this differently at this point. So, on this matter, if SPS can, think about this over the lunch hour, and come back with some response, even if it's, well, we can't, we can't commit to that now, or whatever you're going to say. Let's do it that way and see where we are. All right. Okay. And I believe, Ms. Coleman, you have finished with your cross-examination?
Yes, Your Honor.
Okay. And I believe under the proposed order, we have next the any questions from the large customer group?
Yes, Your Honor.
Go ahead, sir.
Thank you. Good morning, Ms. Sakia. We've met before, but just for the record, Austin Rushoff on behalf of the New Mexico Large Customer Group. I'd first like to ask you a few questions related to the request to assign the unassigned portion of the Roswell and Chavez PPAs to New Mexico retail customers. And in his direct testimony, the New Mexico Large Customer Group's witness, Mr. Kevin Higgins, provided recommendations regarding SPS's plan to assign these PPAs to New Mexico. You're generally familiar with Mr. Higgins' testimony, correct?
I am.
And Mr. Higgins recommended that if the unassigned portion of these PPAs, if assigning that to New Mexico customers was approved by the commission, it should be contingent on two recommendations that Mr. Higgins made. Do you recall that testimony?
I do.
Okay. And Mr. Higgins first recommended that whenever the cost assignment to New Mexico retail customers occurs, it should simultaneously offset by the proposed capacity credit. Is that correct?
Yes.
And then Mr. Higgins' second recommendation, he also recommended that an energy benefit from the direct assignment should be recognized in the fuel and purchase power cost adjustment clause to reflect the portion of the New Mexico retail load that would be served by the directly assigned PPAs. That's correct?
That is.
Okay. I'd like to take a minute and first talk about the energy credit issue that Mr. Higgins raised in his testimony. And if you could please turn to your rebuttal testimony, which has been admitted as SPS 5.
Okay.
And if you could please turn to page 19 of your rebuttal testimony.
19 at the bottom page.
Yes, of the testimony itself. And on page 19 is where you respond to Mr. Higgins' recommendation regarding the energy credit, correct?
Correct.
Thank you. And the New Mexico Large Customer Group asked you a few discovery requests regarding this portion of your rebuttal testimony. Is that correct?
That is.
Okay, I'd like us to please look at those discovery requests and those responses. And those have been marked as exhibits NMLCG 4, 5, and 6.
Okay.
So if we could please first look at NMLCG 4, which is the company's response to discovery request NMLCG 2-1. Do you have that in front of you, and do you recognize that response?
Yes. So it's a response to your question to SPS and MLCG question 2-1.
Correct. And you were the preparer and the sponsor of that response, correct?
Correct. And you have both my written response and my attachments.
That is correct. It's the written response, and then the attachment was labeled exhibit SPS-NMLCG 2-1.
Correct.
And then also looking at exhibit NMLCG 5, which is the company's response to NMLCG 2-2.
Okay, I
And
have
you
that.
also recognize that response, and you were the preparer and sponsor of that response, correct?
Correct.
Thank you. And then finally, if we could look at what's been marked as NMLCG 6, which is the company's response to discovery request in MLCG 2-3.
Okay.
And I'll ask the same questions. You recognize that response, and you are the preparer and sponsor of that response as well, correct?
Correct.
Madam Hearing Examiner, I'd like to move to admit NMLCG 4, 5, and 6 at this time.
Any objection to what's been identified as NMLCG Exhibit 4, which is a discovery NMLCG 2-1, and Ms. Sakia's response? Hearing no objection. NMLCG Exhibit 4 is admitted. I just want to note that that exhibit is 4 pages. Any objection to what's been identified as NMLCG Exhibit 5, interrogatory from NMLCG 2-2, and Ms. Sakia's response. And I guess I need to clarify the Exhibit 4 is actually 7 pages. I didn't see the double side. NMLCG Exhibit 5 is 3 pages. Hearing no objection, NMLCG 5 is admitted. Any objection to what's been identified as NMLCG 6, discovery from NMLCG 2-3, and Ms. Sakia's response, and that's 2 pages. Hearing no objection, NMLCG 6 is admitted. Mr. Rushoff.
Yes, thank you. To clarify, we did admit NMLCG 4 as well, correct?
Yes,
Sorry
4,
if I-
5, and 6.
Okay. All right. Thank you. Ms. Takia, if you could please look at NMLCG 4,
Okay.
which is SPS's response to discovery request NMLCG 2-1.
I have that.
And thank you. In response to 2-1 subpart A, you explain that in order for the energy benefits from the direct assignment to be assigned to the New Mexico retail jurisdiction, SPS will capture the energy benefits through an economic system dispatch model. Is that correct?
It is.
And you further state in that response that the economic system dispatch model is similar to how the uneconomic portion of the Sun Edison PPAs are determined. Is that correct?
Correct.
And then further, you explain that the energy benefit derived from the economic system dispatch model will result in an adjustment to the fuel and purchase power cost adjustment clause. Is that correct?
Can you repeat that? I'm sorry.
Yes, and so it's your position that the energy benefit derived from the economic system dispatch model will result in an adjustment to the fuel and purchase power cost adjustment clause, correct?
It will result in a change to the costs that are included in the fuel and purchase power cost adjustment clause.
Okay. And this adjustment will again be similar to how the uneconomic portion of Sun Edison PPAs are included in the fuel and purchase power clause, correct?
The underlying calculation is the same in that we use a dispatch model. The way it's reflected might be different. And by that,
Okay.
so if you were to look at the form, the FPPCAC 550 Form 1, you actually see a line item on there that reflects the SunEd credits. Right now, we don't believe that we'll have to make an additional line item for this, but if it's possible, we might need to. That's kind of what I'm trying to clarify.
Thank you. And then NMLCG 4, in your response to 2-1B, you also state that if changes to that form are necessary, you would be willing to work with staff and interveners to kind of work through that. Is that correct?
Absolutely, yes.
Thank you. If you could please turn to Mr. Higgins' direct testimony, which has been marked as NMLCG 1.
Okay.
And then if you could please look at page 12 of his direct testimony.
Okay, I am there.
And if you look at beginning on line 8 there, Mr. Higgins begins sort of explaining his proposed recommended energy adjustment. And Mr. Higgins, starting on line 8, explains that SPS should perform 2 production cost model runs, similar to how the Sun Edison PPAs are determined. Is that correct?
It is.
You see that? And to clarify, what Mr. Higgins says in his testimony here is similar to the approach you explained in your response to NMLCG 2-1, correct?
It's similar. They're not, I think I've had subsequent discussion with Mr. Higgins, and I think we might have been talking past each other, but I believe at the end of the day, we're talking about the same thing, which is using a production cost dispatch model to make sure that New Mexico retail customers get the economic value of dispatching the system with the full impact of using 80 megawatts of energy direct assigned to the New Mexico retail jurisdiction.
Thank you. And doing this sort of separate calculation as you described, is necessary because New Mexico, if the direct assignment was approved, will have different resources in its resource stack than other SPS jurisdictions. Is that correct?
Exactly, yes.
And I'm going to go back to NMLCG Exhibit 5, which is your response to NMLCG Discovery Request 2-2.
Okay.
And in that response, you sort of explain the resource stacking concept. Is that correct?
I do, yes.
Thank you. And in the response to NMLCG 2-2 shows that in order for the New Mexico retail jurisdiction to get credit for the avoided energy that comes from its stack of resources, including the direct assigned PPAs, you will have to use the economic system dispatched model discussed in response to 2-1, correct?
Correct.
Thank you. So to be clear, and this is based on the additional information that the company provided in response to NMLCG 2-1 and 2-2, SPS and the NMLCG generally agree about how the energy credit should be calculated. Is that correct?
It is, yes.
And it's no longer your position that if the NMLCG's proposal regarding the energy credit is adopted, that SPS will withdraw its offer to utilize the unassigned energy of these PPAs in its RPS requirements, correct?
Correct. With the addition of the exhibits or the RFI responses that I prepared and that you have offered as evidence.
Thank you. Instead of withdrawing it, you would agree that there will have to be a calculation of the energy benefit and an adjustment to the fuel and purchase power clause if the direct assignment of the PPAs is approved, correct?
Correct. So there will have to be a calculation, as I've described, with the production costing model, and that production costing model will need to be reflected in the FPPCAC. To the extent any modifications to that form are needed, we want to work with all of the parties to this case and staff to make sure that it's appropriately reflected.
Okay, thank you. And just to touch on that a little bit more, in NMLCG 4, in response to 2-1 B, you state that you don't believe, let me make sure I'm there. You state that you don't believe a change in the format of the monthly fuel report needs to be changed to accommodate the energy benefit, correct?
Right.
And that's because the format of the monthly fuel report already allows for similar types of adjustments, such as is currently done for the Sun Edison PPAs. Correct.
There's that adjustment, and there's also later in the report what we call the balancing account, where a lot of times we also make adjustments. And so that might also be where it flows through. And so it's, again, we haven't done this kind of adjustment before. And so that might also be where it's reflected. And so until we do it and actually run through a month, we want to find the best place to record and put this and make sure that all of the benefits really do flow to our New Mexico customers.
Okay. I'd like to switch gears a little bit and briefly discuss Mr. Higgins' recommendations regarding the timing of the direct assignment.
Okay.
And you would agree that generally speaking, Mr. Higgins' recommendation was that whenever the costs are directly assigned to New Mexico retail customers for recovery through rates, those costs should simultaneously be offset by both the capacity credit proposed by SPS and the energy credit or the energy benefit we've been discussing. Is that correct?
That is.
And when we look at your rebuttal testimony, you didn't specifically respond to Mr. Hagan's recommendation that the energy cost and capacity credit should be recognized simultaneously. Is that correct?
That is correct.
But you do now agree that in order for New Mexico customers to get the full benefit of the direct assignment, the costs and benefits should be recognized simultaneously, correct?
We would agree that it would be appropriate that if, for example, that we do the offsetting capacity credit in the rate case that we're filing in the first quarter, probably in January or February of next year, that we would also include the cost component at that same time to match the credit and the cost.
Okay. And that's because you recognize that without realizing the costs and benefits simultaneously, New Mexico retail customers will be paying the actual price for these PPAs rather than the effective price that you discuss in your testimony. Is that correct?
They would still have some of the energy benefits that we just talked about on that exhibit 4, or that we illustrated the energy side. They wouldn't be getting the capacity credit to offset and get the full effective price.
Okay. I'm going to change topics a little bit and talk about the ROE adder incentive that the company has proposed in this proceeding. And if you could please turn to SPS Exhibit 5, which is your rebuttal testimony.
I am there.
And please turn to page 21 of the testimony.
Okay, I am there.
And on lines 5 through 15 of your testimony there, you provide in a block quote, the statute upon which SPS bases its request for an incentive. Is that correct?
It is.
And specifically looking at lines 5 and 16, the portion of the statute you cite states that upon motion or application by a utility, the commission shall, and there's an ellipses, open a docket to develop and provide financial or other incentives. Is that correct?
It is.
And then looking on lines 13 through 15 of your testimony there, you again citing the statute, you quote, and this is the underlined emphasis portion there, you quote that the incentives may include additional earnings and capital investment opportunities. Is that correct?
It is.
So looking at the statute, Ms. Sakia, you would agree that there are a variety of types of incentives, financial and otherwise, that the commission could implement to carry out the directive of the statute.
I would, yes.
And you would agree that the statute does not require those incentives to include an ROE adder, correct?
An ROE adder is one, but not the only incentive the commission could approve.
There's a variety of incentives the commission could approve, and the statute does not require those to be financial incentives, correct?
It could be a financial incentive. It could be other incentives as well, yes.
Okay, thank you. Those are all my questions.
Very well. Drake, did you have any questions for Ms. Sakia?
I have just a couple of questions. A lot of my questions have already been answered by you and Ms. Coleman and Mr. Royshoff, but I think I have one or two.
Go ahead, please.
Thank you, ma'am. Good morning, Ms. Sakia.
Good morning, Ms. Drake.
If you could look at that same page that Mr. Royshoff was directing you to, page 21 of your rebuttal testimony.
Okay.
And if you could look to, I have it at line 16 and 17 of that page. And
okay.
I'll read the sentence and ask you to confirm I'm reading that right. You said the legislature amended the REA by striking language making the award of an incentive optional, and you underline the word optional. Is that right?
Correct.
Okay, would you agree with me that SPS had the possibility or had the option of applying for an incentive prior to this amendment to the REA?
Yes.
And at the time or prior to the company's decision to proceed with the Hale and Sagamore projects, you had the option of applying for an incentive, correct?
We did, yes.
Did you do so?
I believe that at some point we have asked for an incentive, but I don't recall the timing.
So can you give us a ballpark estimate?
I can't. I'm sorry, Ms. Drake. I can't recall.
Okay, sure. That's fine. But
Ms. Lees, consider that a bench request. I'd also like to know whether or not SPS has previously requested an incentive, and in what case number.
Okay.
Thank you. Go ahead, Ms. Drake.
Okay. I think that's all the questions I've got at this point in time. Thank you for the clarification.
Mr. Templeman, did you have any questions for Ms. Sakya?
No, I don't. Thank you.
Okay. And Ms. Zert, did you have questions for Ms. Sakya?
I do. And if I have 15 minutes reserved. If I take 20 minutes, would that be okay? I thought coming later in the stack here would mean my questions would have been more likely answered.
Go ahead.
All right, thank you. Ms. Sakya, I would like you to start at page 20, let's see. Well, let me just ask you, one of the things that you suggest is that SPS should be, the incentive SPS is asking for should take into consideration SPS's past performance, past behavior. So could you explain to me like what specifically you're talking about? Which actions in the past are those historical behavior or performance that show an entitlement to the incentive or that should be incentivized?
I believe what I'm referring to, are you looking at my rebuttal? Is that what you're specifically asking about?
I'm just looking in general. You referred to like on page 26, does it make sense as a matter of public policy to encourage utilities performance by providing an incentive in recognition of prior performance? So my question is, what prior performance, what would you articulate as a basis for incentivization?
What I'm responding to specifically were arguments that SPS should not be rewarded for any of the renewable resources already on its system, including its acquisition of the Hale and Sagamore facilities.
In 2019, did SPS exceed the RPS, the New Mexico RPS, as demonstrated by retiring RECs that exceeded the then applicable RPS requirement?
We didn't retire more RECs than we needed, but we did generate more electricity than the requirements. So we generated more in that year.
You generated more renewable electricity, or you just generated more electricity?
Oh, more renewable electricity.
And when you refer to having generated more renewable energy, more electricity, was that demonstrated by retiring the RECs associated with that energy?
No, it was not.
So let me just give you a hypothetical and ask it this way. So if SPS were to build a new wind generating resource and sell all the RECs, do you believe the legislature intended that performance to be something it wanted to incentivize?
Well, the ETA actually prohibits us from selling those RECs, so I actually don't believe that scenario would work.
You're saying the ETA says you can't sell RECs anymore?
Correct. At least our New Mexico allocation of RECs. I believe that it's very clear that we cannot sell those RECs anymore.
Do you mean you can't sell them and still use them for RPS compliance? Or are you saying you can't enter into a contract to sell, say, excess RECs?
I don't believe we can sell excess RECs anymore.
Is there a statute or rule that you could point to that says you can't sell RECs anymore?
Yeah, if you give me, it might take me a few minutes, but that's the interpretation we've been following since the passage of the ETA.
All right, could I withdraw my question? I don't really want to take the time for you to look at that right now.
Okay.
Okay, so let me just, on page 23 of your direct testimony, you referred to 8 resources. SPS, this is at lines 4 and 5. I'll just read it. SPS has already shown it is a leader in acquiring low-cost renewable energy on behalf of its customers. Since 2013, SPS has demonstrated this commitment by signing 6 renewable energy PPAs, totaling over 1,000 megawatts for economic reasons. That's your testimony, right?
Yes.
Did SPS retire all the RECs associated with that 1,000 megawatts of resources?
Not necessarily in that year, no.
Well, were there PPAs in those 8 resources for which SPS solely procured energy and no RECs?
Hold on. Are you in my, I'm sorry, are you in my direct testimony?
Yeah, page 23.
Okay. Let me just get to the right table so I can make sure I answer accurately.
Sure, and I don't necessarily want to ask you for each of the 8. Just can you tell me, are any of those purely economic resources for which SPS does not retire RECs?
That's what I'm trying to see if I can remember.
Okay.
Some of those probably were for economic resources only. Of course, in this proceeding, we're asking for approval to acquire the RECs with the energy so that we can have a matching of the energy and the resource and use the RECs for compliance purposes.
So you're saying now you're able to, I think you used the word sync the RECs and the energy, and therefore use it for RPS compliance purposes because that qualifies as renewable energy, correct?
It would give us the compliance component, correct?
So before you were retiring RECs, was that still renewable energy? That let me just give you an example of just the PPA, one of those PPAs in which you were only acquiring energy. Is that a renewable resource?
Probably depends on who you ask. We did not use it for compliance.
Okay.
But just so that I'm clear, Ms. Sakia, SPS has renewable resources that it has acquired on an economic basis that it does not use currently for renewable compliance, correct?
Correct.
Okay, including the, as you just answered the question, including the Chavez Roswell, correct?
Yes.
And including Hale and Sagamore, correct?
Hill and Sagamore were acquired as renewable resources, but they are owned resources and we do get the RECs. And part of the stipulation, and I think it was maybe 2 RPS cases ago, the commission determined that we should use the RECs from those facilities, the New Mexico allocation, toward our RPS compliance.
I seem to recall that at the time the case was done, it wasn't being touted as being used for renewable compliance here in New Mexico, that was asking to be approved on a total economic basis.
It was approved on an economic basis, and then the issue of whether or not we would use it for compliance as part of the stipulation was deferred for a renewable case, and the commission determined in the renewable case that it was appropriate to use those RECs for RPS compliance.
And do you know which case that was?
Not last year, but I believe it was the year before.
Okay, Ms. Lees, consider that a bench request that I get that case number 2, please. Go ahead, Ms. Sutter.
Was that case 18-00201 that you're referring to? I mean, SPS, I'll just go ahead and I looked at it this morning, and SPS had requested permission to, that was the case you deferred the question to, whether to sell the RECs or so forth. Because I actually wanted to ask you a question about that case.
Are you familiar with that case, Ms. Sakia?
I am.
Okay, is that it?
That sounds right. If you would, we'll still answer the bench request so I can verify for you, but that sounds like the right case.
Okay.
So you recall that was the case that Steve Michael of WRA was a witness in that case, right? How could you forget that?
Correct.
Okay. So am I correct that in 18-00201, SPS asked for permission to, and this is if you recall, they asked for permission to apply the RECs towards the New Mexico RPS from Hale and Sagamore, but to sell RECs that exceeded SPS's RPS requirement and apply the benefits for customers, and with a 10% fee to SPS for selling, I guess, an incentive. Is that a long question?
Yes, we did make that request.
Okay, I'm sorry about my rambling questions, but so that is your recollection. Okay, and do you recall what the commission did in that case? Did they grant SPS's request to do that?
I know the commission granted us approval to sell the RECs. I can't remember where they went on the margin sharing component. And the reason I don't remember is subsequent to that, the legislature passed the ETA. We actually never sold any RECs under that because, and again, maybe it's a different interpretation, but we've interpreted the ETA to say that we can no longer sell the RECs, which is maybe a moot point anyway, because the standards are so high, we don't have any RECs to sell anyway.
Okay. Let me ask you about your plan year and your next plan year. So you indicate that you will be able to meet the minimum plan requirements, the RPS requirements for the plan year and the next plan year, correct?
Correct.
If you'll turn to your rebuttal testimony on page 33 now.
Okay.
Okay, so in your table, RMS R3, you show a number of RECs being generated And I believe this exhibit is just to show SPS with Sagamore 47% in 2021. Am I reading that right? What does that 47% represent? What is that number?
That's renewable energy generation, and that's with the RECs. So that's only renewable energy generation in New Mexico of our, let me restate that. That would be renewable energy generation with RECs allocated to New Mexico compared to our New Mexico, or let me state this again, take 3. Our New Mexico retail load compared to our New Mexico our generation, oh my goodness, I'm not doing this well at all. It is the amount of generation that's assigned to New Mexico that's renewable. So we have 47% of our generation that's allocated to New Mexico that is renewable, that has a REC with it. So anything that does not have a REC is not included in that number.
So earlier I just asked you about the plan year and the next plan year, and you said that you agreed with me. Your testimony says that SPS will meet the minimum 20% overall requirement in those years, the plan year and the next plan year. So does that mean, so what should we understand from that 47%? Does that mean SPS is actually going to exceed the minimum requirement? Is SPS going to retire RECs representing 47% in 2021 of the RPS requirement and 43% in 2022? Is this represent?
Hey, stop. You're compounding questions.
I am. I'm sorry. I'm just so confused. I apologize. Can I just withdraw that and start again?
Sure.
Okay. I need to learn how to do this. I'm so sorry. The 47% SPS with Sagamore, page 33 of your rebuttal testimony, does that represent the amount of renewable energy for which SPS will retire RECs in 2021?
No, it represents generation.
And the same question for 2022.
It represents generation.
The 43%.
Correct.
So am I understanding correctly now that in the next couple of years, SPS is not planning to exceed the RPS as by retiring RECs exceeding the 20% RPS requirement for 2021 and 2022?
I guess there's maybe a difference of interpretation. We plan to have generation on an annual basis that exceeds the minimum requirements. We were not planning to retire RECs on an annual basis in excess of in excess of the requirements. We were planning to bank those RECs so that they can be used in future years.
So basically, I think I was confused about what was going on because of the discrepancy between your minimum requirements that you're asking for approval for, but you're talking at other points about exceeding the RPS. So would you agree with me that in order to exceed the RPS, you have to retire RECs?
No, not necessarily. I had not thought or read the statute in that way. I had read the statute related to the amount of generation that we had each year.
Can I point you to 6216.4?
Okay.
A, and this is the renewable portfolio standard, and it says and I'll just read it. A public utility shall meet the renewable portfolio standard requirements as provided in this section to include renewable energy in its electric energy supply portfolio as demonstrated by its retirement of renewable energy certificates. Okay, so to exceed the RPS, to exceed the 20% by, say, in 2021, you have 47% SPS with Sagamore, RPS achievement. Wouldn't you agree with me that to demonstrate that SPS achieved 47%, it would have to retire all of the RECs associated with the 40% renewable energy?
I'm not sure about that. I do see what you're saying, that for each year, an annual requirement. I'm not certain about how it applies to a financial incentive. I've honestly not spent enough time looking at the statute to know if that is a conclusion that can be reached or not.
Let me refer you to 6216.4E, and that's the part about the incentive.
Or
And
D?
4E. If in any given year, a public utility demonstrates that the average annual levelized cost, I'm sorry, let's see. I am looking at the wrong section.
I think you want D.
Yeah, I do want D. All right. Okay. Do you have that in front of you? It's the very first sentence in the incentive part. I have it here.
I do.
Could
Would you like me to read that?
Yes.
Okay. Upon a motion or application by a public utility, the commission shall, or upon a motion or application by any other person, the commission may open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standards set forth in this section.
Yeah, I'm going to stop you right there, because that's the first. Would you agree with me? The first of the different possibilities for earning an incentive, right?
Correct.
Okay, so that clause ends with the words to produce or require renewable energy that exceeds the applicable annual renewable portfolio standard. So wouldn't you agree with me that this incentive is not just for generating, for producing and acquiring renewable energy, but it has to be producing or acquiring renewable energy that exceeds the applicable renewable portfolio standard?
Well, possibly. Again, I'm looking at this right now for the first time, and let's be clear, I spend a lot of time interpreting and reading statutes, but I'm definitely not a lawyer. So while I spend a lot of time with these, I have not spent a lot of time considering what you're asking me to consider. So
okay. I'm asking you to put a lot of pieces together. I guess it's kind of confusing, but so the 47% we talked about, SPS with Sagamore, in that chart, SPS considered that to be generating that energy should be an achievement that's incentive worthy. And I'm simply pointing out to you that it does say produce or acquire renewable energy in the statute, but it also says that exceeds the applicable annual renewable portfolio standard. And I also pointed out exceeding it is demonstrated by retiring RECs. So do you see what I'm getting at here? Maybe you're missing a requirement.
I need to object in here. I think Ms. Deser is testifying more than asking a question right now, and I haven't heard a question to Ms. Sakia.
I'll withdraw that so that I don't waste your time. The first clause that you read, doesn't that seem to say that just acquiring or producing renewable energy isn't enough? It also has to exceed the annual renewable portfolio standard. In other words, use that energy in that way?
right. Again, I see where you're going. And what I'm saying is I have not taken the time to really review this statute and make sure that I fully agree. I agree with what you're saying, that maybe that's the correct interpretation. On first blush, I haven't spent a lot of time and had the opportunity to really gather my thoughts. And if you're making kind of legal interpretations, I'm a policy person who applies this. I cannot make those conclusions.
Okay, I understand. I will move on at this point, and I just have a quick kind of follow-up. So this is about the reallocation of Chavez and Roswell. And I understand parties have objections because they wonder if maybe a new procurement might reveal lower prices. So my question to you, is it a possibility that SPS just allocates the Roswell and Chavez for its current plan for which it's seeking approval, to allow the commission to further consider maybe in the future if that is the most economic resource? Is it an all or nothing proposition?
Wait, I'm sorry, can you ask your question again?
Can it just be for a year, for the next plan year, this reallocation, or does it have to be permanent?
I don't actually know. I would have to take that back. And I think Madam Hearing Examiner has asked us to consider OPL's proposal during the lunch hour. I have, again, not considered that proposal either. And so I would need to take some time. And if you would like, and Madam Hearing Examiner would like, I could also consider that during the lunch hour.
Okay.
You know, I mean, I think that's fine. Again, you know, trying to introduce new stuff in it, you know, at the hearing is not necessarily fair to you know, to all the parties in, you know, we don't necessarily have evidence to support, you know, things that are thrown out at the hearing, but to the extent you can, I mean, SPS can consider that too, and at lunch and come back to me. Anything further, Mr.?
Yeah, my last question, thank you. If the commission were to authorize SPS to allocate Chavez and Roswell as requested, would that be an incentive to SPS in the sense that right now SPS has an unallocated portion for which it may not be recovering all of its costs?
I don't know if it would or not. Possibly.
All right.
I mean, I guess I don't, certainly I don't consider it perhaps an incentive in the sense that we believe that what we are proposing benefits New Mexico customers just as everything else benefits New Mexico customers. So certainly SPS has a loss, but we're not proposing anything that we don't believe isn't beneficial to our customers.
Well, isn't it also beneficial to SPS that they could recover costs they're not now recovering?
It does have a financial benefit to us as well.
Okay, thank you.
Also, just in terms of these proposals that are being thrown out here today, so far we have 2 of them. I mean, I don't know necessarily even if the particular parties would get an agreement with SPS that they're willing to modify their proposal. I don't know that the rest of the parties would agree to those things. So, I mean, that could just be a deal between, you know, whoever's making this proposal, again, you know, without some kind of evidentiary support necessarily, unless it's already included in the case. So I just put that out there. And Ms. Beatles, did WRA have questions for Ms. Sakya?
No, we do not. Thank you very much for asking.
Okay, very well. And Mr. Baracco, you do have questions for Ms. Sakya?
Madam Hearing Examiner, I do
Okay.
have 2 questions.
Okay, I think we'll have you after lunch since we're close to the noon hour. And we're going to recess for an hour and we'll come back at 1 and and let you ask those questions, Mr.
Thank you.
Very well. Okay, remember again, I'm not going to shut down the feed, so want to remember you're on the camera and you're on the audio. So we're recessed until 1. Oh, before we recess until 1, actually, I was able during the break to look, and you are correct, Ms. Lees, that the PDF you sent last week did not include the attachment. So I actually have sent the corrected one that you circulated, or actually that Mr. Settles circulated. So I've sent that off to go to the court reporter as the correct one. So
Thank you.
with that, yes, ma'am.
Madam Hearing Examiner, I just wanted to check on our time after lunch. I was assigned another PRC hearing at 2 o'clock, and so I need to let my office know that they need to get someone else to cover that if we're going to go past 1:45, which it looks like we probably know.
Well, let's talk about that then. Let's go off the record. We have how long do you have, Mr. Blatko?
Madam Hearing Examiner, I think I reserved 20 minutes, but it's been substantially pared down due to the great work of all my predecessors.
Smooth. Bad that's not on the record. Okay, are you going to have a significant amount of, I have a few questions, not too many for Ms. Sakia. Redirect from you, Ms. Lees.
I will have redirect. I can't imagine it going over 15 minutes, but I haven't heard staff questions or your questions yet, Madam Hearing.
Okay. Okay. And then I just have a few questions for Mr. Pollack. Did anyone else have questions for him? I don't think they did. So that shouldn't take too long.
I do have just a few questions for Mr. Higgins. It should only take about 5 minutes.
Okay. It's liable to be tight. I mean, do we want to cut lunch? We can go ahead and keep on going, Melissa, if time's a factor.
Madam Hearing Examiner, I have arranged for folks to discuss the proposal at OPL.
Right.
I'll bring up the CCA proposal as well, CCA proposal as well.
I'm just going to call my office. I'll just call the office and let them know it's going to be very tight, and we'll go from there.
Well, or you know, or we can take a half-hour lunch if people think that. You know, I mean, that would give us 1:30. Yeah, you know, Melissa, I think it might be too tight.
Okay, I'll just let my office know that they got to do something else. Thank you.
Okay, and you let me know if that's a problem. Well,
We
you know,
can't let
I guess we're
everybody know
either
that way.
gonna, yeah, we're either gonna recess for an hour or, I don't know. I think we can do it if we just have a half-hour lunch.
That's fine with SPS, Your
What do
Honor.
parties think? Is anyone opposed to that?
I'm not opposed, but I have another client matter I need to deal with over the lunch hour. So I would just ask to be excused to come and go. And I will certainly be back before I need to ask for admission of Ms. Alderson's testimony.
Okay.
Thank
Ms.
you.
Khrushchev? Nope, you've just muted yourself. Okay. Oh,
Yep, that's fine with me.
Why don't we do that? We'll recess till 12:30, and that'll give us close to an hour and a half.
Okay. Very well.
To finish up.
Okay.
And I think we'll get finished.
And Hearing Examiner Hurst, in order for me to talk to folks internally and for Ms. Sakia to talk to folks internally, we are going to have to log off this Zoom call. So we will be able to get back on, correct?
Okay. Sure. Yeah. And if I was more experienced, I could put you in a super secret chat room, but
that's not necessary.
That yet. So yeah, I'll bring you back on. So we'll recess till 12:30 and then we'll come back and hopefully finish up.
Okay.
Okay.
Great.
All right.
Thank you.
Thank you.
Thank you.
Thanks.
Do-do-do-do-do-do. That was a big sigh.
Yeah, just trying to keep everything going.
Yeah.
And get my dogs out.
I hear you.
They were
Hearing snoring.
Does anybody not have animals at home?
No, we're in big trouble. We have 4 dogs. We have 6 chickens, 5 rabbits.
Should I count the pack rats?
Yeah, that pack rat's bigger than my chihuahua. So you count the pack rat if you want.
Yeah. Okay. All right. We've got the court reporter. Yay, Melissa. All right. I guess I have to. Oh, 2 people are waiting in the waiting room. Well, let's admit them. Okay. Okay. I think we've got them admitted now. Okay, there's, all right. Okay, well, I think we're all back on, so.
Hey, Madam Hearing Examiner, if you have a second to entertain a procedural question.
Okay.
I think it could result in a substantial time savings if everybody just waived their questions for Miss Leyba Tercero. What do you say?
I'll waive mine.
You mean being that I'm the only one that has any questions for her?
Well, I don't want to hurt your feelings. I know how
Yeah.
thorough you are.
There's not that many.
All right, I just had to make a go of it just in case.
Just in case, okay.
Thank you.
Well, let's go back on the record and Ms. Lees, anything to report that occurred during our abbreviated lunch period?
Besides me rating my 2-year-old snacks.
Oh, those are fighting words.
I did get protein though, string cheese.
Excellent.
SPS, in terms of OPL's request in this case, SPS is willing to provide a written response to their request. Madam Hearing Examiner, if you would like that to be a bench request response, that's fine. If not, we'll just provide it to OPL. It's difficult for us to evaluate their request on the fly in the hearing. So that's the preferred route for us.
Anybody know who 801-355-4365 is?
I believe that's Mr. Higgins.
Okay. Well, he hung up.
Uh-oh.
So, you
It
know,
looks like he's connecting.
I guess I'm just really, I just don't think we can have a good record on things that are just thrown out at the hearing. So I'm not going to require that it be a bench request, Ms. Lees. I mean, you can communicate with OPL as, you've indicated you'll give them a response. That's fine. Ms. Coleman?
Your Honor, that works for us. I mean, I think it's a modification to their proposal. So in terms of the record, I think the evidence that would be needed to evaluate it in terms of party impacts is probably the same, but I understand your point. I think, to the extent that it's something that we'd like to address, we can raise it in briefing and other parties would have a reply brief as well.
All right. And Ms. Lees, what about with regard to Ms. Zer's question?
Yeah, I did ask my client about that as well, and they're not willing to have this only be for 1 year. They need more certainty than that. So So we're not willing to agree to that.
All right, so we have a response on that. And I think we can go ahead with our questions. And Mr.
Ms. Hurst,
Yes.
Hurst, I do have some case numbers for you that you had issued.
Okay.
Request. Would you like me to go through those quickly?
Yeah, go ahead.
Going backwards, in terms of the case number in which SPS, which addressed the Hale and Sagamore's use of racks, for SPS's use of Hale and Sagamore racks, that's 18-00201.
Okay.
And then I'm trying to interpret my notes, I'm sorry. Oh, the rulemaking, excuse me. I couldn't read that. It's 19-00296.
Okay, so you still owe me the case number or case numbers regarding any incentive requests.
That's correct. I just didn't have time to do that. So.
Okay, very well. All right.
And can we mark those bench requests as done? I don't need to follow.
Yes. Okay, very well. All right, if we don't have anything else procedural, Mr. Bracco, you have questions for Ms. Sakia?
Yes, I do, and I presume we're back on the record?
Yes, we have been on the record, yes.
Thank you, Madam Hearing Examiner. Good afternoon, Ms. Sakia. How are you today?
Good, thank you.
Can you hear me all right?
I can.
All right, I was going to direct you to page 57 of your direct testimony, where you talk about the Solar Connect premium calculation.
Okay, give me just one moment to get there. Okay, I am there.
And I believe that you discussed that Solar Connect premium calculation on page 57, and it runs through page 58. And that you also
Correct.
talk about it in the context of advice notice number 289. Is that correct?
Yes.
All right, now keeping all that in mind for the moment, do you recall the letter that was filed in case number 18-00308-UT recently here just this past September?
Yes.
And do you recall that letter discussed some issues with the Solar Connect program, and I believe, if I remember correctly, a delay in construction? Is that correct?
Yes. So would you like me to explain? I'm probably getting
If you'd like to elaborate a little bit, that would be, I would accept that. Thank you, Ms. Sakia.
Yes. So the developer had some issues with construction. We have heard as early as this week they are still on target for a mid-February date. And so what that leaves us is a bit of a gap. We are planning to make a filing with the commission here sometime in November with a proposal, which we don't have fully ironed out yet, but with a proposal to fill in the gap between mid-December or so, when our current wind source program were to expire and when the new Solar Connect program would be effective. As part of that letter or filing or whatever the appropriate mechanism turns out to be, and as part of that filing, we'll ask the commission more than likely to, for example, suspend the advice notice that we hope gets approved in this filing so that we don't have two rates going on at the same time.
And just for the record, that letter that was filed in 18-00308-UT was dated September 18th, 2020. Is that correct?
I don't have it in front of me, but that sounds right.
All right. Well, my next question then is how, if at all, does the situation described in that September 18, 2020 letter and what you just laid out for us affect the request for the approval of the 2021 Solar Connect rate rider that's depicted in advice notice number 289?
It would be SPS's request that the commission still approve that rate rider because the evidence in this case supported the calculation of that rider. However, we do believe it will be appropriate, whether it be a follow-up in this proceeding or that 18 case that you cited, that SPS will need to make a filing or a letter or some, like I said, I don't quite know the procedural nature, that will need to temporarily suspend or delay the implementation of that rider or the effective date until the new facilities become operational, which I believe based on the representations made by the developer should be mid-February, probably between the 15th and the 20th of February.
Well, does that mean, just so I understand, you want the commission to approve the rider? Are you going to go ahead and collect on the rider before the facility is operational?
No, ma'am. What we would like would be the actual rate calculation or the methodology and the resulting rate to be approved, but the effective date of the rider to not be effective until the facilities are operational.
Okay. Mr. Vacco?
And then just in brief follow-up to that, what is your read or what's your operational date for those facilities, if you would, Ms. Sakia?
We believe those facilities should be operational mid-February. So I'm using probably February 20th.
And is that firm or is that subject to change, depending on further developments or delays?
It could be subject to change. So far, that's been a very consistent date. So I'm feeling very good about it. Again, that's why we put in that September letter, though, that we would file and update the commission in November, so that when we came in with a proposal of what to do in the interim period, that we had a good solution and we weren't coming in 2 or 3 times to the commission. And at that point, some other big milestones, including interconnection, should be a lot more firmed up and we could have more certainty for the commission.
All right, thank you for that explanation, Ms. Sakia. I'm going to switch gears now and move back to some of the same subjects we've been discussing here today. Can you confirm that SPS currently projects that it will be able to meet its RPS obligations through 2026 with your existing resource portfolio?
Yes, and I believe Mr. LC also testified to that this morning.
Okay, so that being the case, is it then fair to say that SPS will be able to comply with the increased RPS requirements in 2025, even if the commission does not approve SPS request regarding the unassigned portion of the Roswell and Chavez PPAs?
Yes.
All right, well, if the commission does approve SPS's request to exercise its REC purchase options for the New Mexico retail allocation in the 5 renewable PPAs with NextEra Energy, how far beyond 2026 will it extend SPS's projected RPS compliance period?
I don't remember those answers. Mr. LC probably was the better witness to give you those answers. I'm sorry.
Well, I guess I blew it with Mr. LC then, but can you at least give me a ballpark? Are we talking in the neighborhood of 2030 or 2032, if you know?
I'm sorry. I know I would just be speculating. I know that it extends and it certainly gives us additional headroom and additional time. And I know Mr. LC during his testimony and some of his discussion with Madam Hearing Examiner, is explaining why we thought that it was a good idea to have those recs. And so certainly that whole discussion would apply to your line of questioning here.
All right, well, fair enough, Ms. Sakia, thank you. And then I did say I'd try to keep it brief, and I think I'm on track to doing that. Here's my next question. And we're going back to the Roswell and Chavez PPAs for context. Now, is it possible that a new renewable energy resource procurement might be more cost effective than older procurements such as the Roswell and Chavez PPAs?
They could be more cost effective. They might be more costly. So Mr. Pollack had a chart in his testimony. I don't know that I have it right up, but if you recall that chart, it kind of showed an increase from 2022 to 2025 in both wind and solar prices. So they may be less expensive, but they might be more expensive.
And that still holds true, even though we're talking about, I think, procurement for those two resources that's approaching, what, 5 years in vintage?
Yes.
Well, I think that might be it, Ms. Sakia. Like I said earlier, off the record, but to make it clear, a lot of my questions got knocked out by a capable counsel that came before me, and I'm not going to trouble you any further. You have a great afternoon. Madam Hearing Examiner, I turn it over to you. Thank you.
Sakia, were you listening to Mr. Elsie's testimony?
I was.
Did you hear the question he deferred to you?
I did, about the matching principle.
Uh-huh. Are you familiar with, you've testified in some rate cases, correct?
I have.
And so you're familiar with that, trying to match the time period and current customer with the expense principle?
I am.
And so what would your answer be with regard to my concern about having this significant amount of banked recs that you're buying now, and people now are paying for that, but maybe might not benefit from that if they're not an SPS customer 5 or 10 years down the road, and whether or not that potentially violates that matching principle.
I would say that the ETA, as it amended the REA, really fundamentally starts shifting some of the traditional rate making principles that we've been operating under. And let me take a moment here. So obviously, like under the findings of the ETA, or the REA, I should say, you have things like under A5, a utility should have incentives to go beyond the minimum requirements. And then you have, so I don't paraphrase or just throw it, but there's this section, for example, that says that a utility, even if you have a renewable energy certificate that expires, let's see here, 62.16.5B2, kind of near the end, the commission shall not disallow the recovery of the cost associated with any expired renewable energy certificate. So that kind of speaks, in my mind, to this issue that you might have more RECs than you need, potentially due to a banking issue. That because of the way a system is designed, that the renewable energy the energy we generate, we don't have storage on our system right now, has to match the actual load. The only way you're going to have expired RECs is because you had some that were banked. So the statute itself says to me that it has now created a different paradigm than we were operating under before, where you really had kind of a system of matching. But I would also say that even under the existing paradigm, when you built these big generation plants in the past, traditional generation, a lot of times you would build slightly bigger than you needed, and a utility and their customers grew into those plants because they were such big investments and such time intensive, labor intensive, land, siting, everything. You didn't size it always right as you needed. A lot of times you had to grow into it. So even historically, you kind of had a system where they weren't exactly matched, that you knew we had to grow into things. And so this is a little bit different than maybe a coal plant or a nuclear plant, but the ETA, I really believe, has said there's a little bit different set of regulatory principles that we're going to operate under.
But in those generation cases, I mean, whatever wasn't going to be used and useful got disallowed, didn't it?
Well, what used and useful, it is disallowed. But when, for example, when I first started generating and it didn't match, it was bigger, that wasn't disallowed, because there was, when you come in for a CCN, a recognition that you're building a little higher now or greater capacity now so that you could grow into it, because the benefits of building a little more now were outweighed paying a little higher now so that you could grow into it. Because trying to build a coal plant every 2 or 3 years was maybe not always in the best interest of your customers.
Right, but we're not talking about something that's actually being utilized to provide service to the customer, correct? When we're talking about a REC, I mean,
well,
it's not actually all of these banked RECs that we're talking about are not all being retired, right? They're being banked.
So the underlying energy is used during that time period, but the REC itself, when it's used for compliance, will be used at a later point in time.
So you're saying that all of the energy that's being produced for these excess RECs is produced in the time period and in the New Mexico jurisdiction.
Or assigned to, I mean, the electrons flow where the electrons flow, but generally speaking, yes.
Okay, so the disconnect is between what's actually being produced and what needs to be retired via the REC for compliance purposes.
Correct. But again, that's where I think you have to rely on what the ETA establishes, which says that a REC has a shelf life of several years, that you can hold these and retire them into the future. And that's a shift in the way that maybe more traditional rate making has been treated.
Well, at least for right now, and maybe forever, I don't know. The only place that you can utilize those RECs is here in the state of New Mexico, correct?
Now, historically, we could sell the RECs depending on your market. Sometimes they could be used for compliance purposes and then sometimes for voluntary purposes. Now, my reading of the statute is that under the ETA, SPS can no longer sell RECs allocated to the New Mexico jurisdiction.
Right, and I guess my point was you don't have any type of renewable requirement in Texas, correct?
We do have a renewable requirement, but it is much smaller in Texas.
And do you, for compliance purposes, do you retire RECs there?
We do.
Okay. I wanted to ask you, in looking at and looking at your rebuttal testimony, and with regard to the incentive and I know in response to your question, I believe from I think it was Ms. Coleman, it could have been Mr. Rushoff, about one of the discovery requests. You made a response regarding why you thought SPS should get the incentive, correct?
Yes.
And I know, for example, in your testimony on page 5 of your rebuttal, and you're talking about lines 12 through 16, talking about that the utilities should recover reasonable costs incurred to procure or generate energy, and utilities should be incentivized to go beyond the minimum renewable portfolio standards prescribed by statute. Correct?
Correct.
That's your testimony?
Yes.
But yet, and you in your discovery response have said, yeah, it's reasonable because we're asking for it. Correct? We should get it because we asked for it.
No, I should clarify, reasonable costs, the recovery mechanism would be, for example, our RPS rider for the cost that we use to meet the RPS, and then the second clause of the statute related to the incentive would be, the statute says shall, let me try to get to the right language so I don't paraphrase the statute. Shall develop and provide upon motion
of
a utility.
And I guess my question is, you're familiar with Mr. Pollock's testimony, correct?
I am.
And he refers, in his testimony, and it's, his position regarding incentives, and part of his testimony, he refers to the Texas case that disallowed a certain amount of, I'm sorry, I'm referring to the wrong testimony. It's Mr. Higgins' testimony I want to refer to. You're familiar with his testimony?
I am.
And he refers to he refers on page 16 of his testimony at footnote 19. He refers to a Colorado PUC case, decision number C20-0505. Did you see that footnote?
I did. I have not, however, reviewed that Colorado decision.
Did you testify in that case?
I did not.
Well, basically what he's saying is that one of your sister companies went into the PUC in Colorado and asked for a higher ROE, in part because it was leading the transition to clean energy economy. And that basically the Colorado PUC said compliance with statutory requirements isn't a basis for supporting an ROE higher than the evidentiary record. So you're familiar with that?
I'm familiar with Mr. Higgins' response, or at least
Yeah.
the footnote, I should say.
Okay, and I just wondered how you put that in context with, so you're complying with the ETA, and you've even made some economic decisions in the past that utilize renewable energy, at least at the time, on an economic basis, and so wouldn't you say that was a smart business decision?
I think so. I guess I would respond probably in two ways. One is I'm not particularly familiar with the Colorado statute, and so I don't know if it has the same statutory language that ours does. But I would say, regardless of what decisions the Colorado Commission may have made, I think from an economic perspective, like I talked about in my rebuttal testimony, if I'm looking at an employment example, it just occurs to me, if we're trying to incentivize behavior, you want to incentivize your high performers, your people who are doing well, who are making the decisions you want them to make. If they are good actors doing what you want them to do, you want to continue to encourage them to do it. If you have good employees who are just good employees, regardless of the fact that they are internally motivated, of course you want to reward them. And it seems to me that if we're a good company making good decisions, of course we want to incentivize us. And particularly if we continue to do things that are in the interests of our customers and our communities and our state, then it's both good for our companies, our customers, and the state and SPS. It doesn't seem to me that it has to be mutually exclusive.
And I guess I'm just wondering, I mean, if your employees are making good decisions and your company's is employing good employees, I mean, it's to their benefit, isn't it? I mean, if you have good employees that make good decisions, your company's going to make money, isn't it?
It absolutely. And that's exactly what I think the statute's trying to encourage. It says, keep doing the good work you're doing and keep making good decisions for everybody involved.
Okay. I guess I've never thought of being a good employee or being a good anything that you have to get paid for it. It seems like that the company wants to have smart employees because it wants to make a profit. It doesn't want to have smart employees so it can get some incentive under a renewable statute.
Well, I guess I was thinking more like when I was bringing that example, just like compensation. Like you're a good employee, I'm a good employee. If I go and there's a poor performing employee, I expect to be paid. I'm going to do a good job no matter what, but I think a paycheck is really handy. I still have a house payment. I still have kids, animals, everything else. And if there's a poor performing employee, it doesn't seem to me that the incentive mechanism should be, hey, poor performing employee, if you come up to speed and do what Ruth does, we're going to give you an incentive. And Ruth, you're already good. You're internally motivated. We aren't going to give you anything. That doesn't make a lot of economic sense to me. It really says, oh, hey, Ruth, we're going to pay you well because you've done well. And we want you to keep doing well. And we want you to do even better. That's where I'm kind of trying to go with my example.
Right. And you fire the poor performing employee, don't you?
We should. Or you give them a chance to kind of move up and get to the point where the other employees are. You work with them, and obviously the incentive's there that says, hey, this is what you could achieve. So if you're not the top performing utility, you look and go, wow, financially, you could be there. There's an incentive that exists. And if you're already the top, you say, hey, we want you to do even better because it's in the interest of everybody if you do better.
Okay, well, I guess it's just a difference in perspective. You know, it just seems like, you know, the claim that some of the interveners are making about, you know, SPS making decisions, which, you know, I could, you know, characterize them, I think appropriately, as good economic decisions. You know, I mean, that's, you know, what I heard, you know, day after day in your 17-00044 case. It's, hey, not only, you know, this is going to be, you know, great, these wind farms, and no, we're not doing it because it's renewable. We're doing it because look how the numbers shake down. You know, the economic, you know, we're doing this from an economic perspective, and you know, that's the tune I heard, and that totally made sense, and you know, and I recommended that, but it wasn't, you know, at the time it wasn't the position of the company that, oh, you know, we want to, you know, be, you know, lead the charge in renewables. So I'm not saying that I don't think that there can be more than one purpose for doing something. It just seems like, to me, I'm trying to figure out, you know, when should somebody get rewarded, you know, for active active steps or active proposals, as opposed to a serendipitous, potentially serendipitous action. But now I'll ask you the question about Mr. Pollack's testimony, and that had to do with the different, a different project, and it's the Roswell and Chavez PPAs, and you indicated you're familiar with his testimony, Ms. Sakia.
I am.
And the case that he refers to with Texas, I think he cites on page 6 of his testimony as a Texas case, docket number 48973. Are you familiar with that case?
A little bit, I am, yes.
Okay, did you testify in that case?
I did not.
But it's my understanding that the Texas Commission disallowed $3.1 million of the PPA price. Is that correct?
Yes.
And so that basically led to the impetus then for SPS to want to assign all of the Chavez Roswell PPAs to New Mexico, correct?
There was, well, and on a going forward basis, SPS is not able to recover any of those costs. So we now have approximately 80 megawatts of unassigned capacity from these PPAs available.
Could you not sell that on the wholesale market?
It is possible, and currently we are making sales on the wholesale market.
Is that more or less lucrative than trying to assign it to New Mexico?
Depends on the gas prices. Right now, I don't know if I'd characterize it in terms of lucrative. Right now, we are not breaking even on the contract. If gas prices change, the economics of that would also change.
So if gas prices went up, then you could make a profit.
Potentially,
Or costs, pardon me, cover costs and potentially make a profit, correct?
yes,
But at the contract cost price that you're asking the commission to approve, you will cover costs, correct?
yes.
And you'll make a profit, right?
What we're asking the commission to approve in terms of assigning to New Mexico?
Yes.
No, we won't make a profit. No,
On that 80 megawatts, you won't?
no,
You'll only cover costs,
correct,
including covering costs of the RECs?
correct.
But there seems to be a different school of thought that maybe the costs that you want to cover are high. Is that correct?
Correct.
So do you understand why that some of the interveners might see that you're trying to take a cost that was considered by the Texas Commission to be too high and sort of dump it on the New Mexico customer?
Right, and that's exactly why, in consideration, first and foremost, we proposed the capacity credit, which we believe is theoretically appropriate, but also because it does reduce the effective price. And then in our minds, we had already contemplated the energy offset, but Mr. Higgins in his testimony highlighted the importance of the offsetting energy credit. And then, of course, as I talked about in my rebuttal, there's the offsetting credit for any sales, and then the application of the market revenue. But those components are important for the New Mexico jurisdiction.
And just so that it's clear for the record, Ms. Sakia, if you look at page 19 of your rebuttal testimony, and the question that's posed at lines 10 through 11, and then your answer from lines 12 through 14, I thought I heard you say in questioning that you no longer advocate that position?
Correct, as long as it's clear that at Mr. Higgins' position as supplemented by the additional exhibits that included my responses in discovery with an outline of further clarifying how the energy allocation is treated.
Okay. I also want to get a clarification of your testimony on page 27 of your rebuttal. Question posed at lines 1 and 2, as SPS improved its RPS performance and added carbon-free generation since the ETA was enacted. And at line 4, you say, SPS decided to move ahead with the construction of Sagamore Wind Project after the ETA was enacted? Are you sure about the timing on that?
Yes. So we were in the process of the case, but there was still a lot of moving parts in terms of whether or not we should go forward with the actual construction. And so the construction decision came after the ETA was enacted.
But didn't you decide about the construction before you filed the application in that case?
You continue to make construction decisions as you go forward, and you have transmission, interconnection, other cost factors can still move. So I'll give you the example. Mr. Lagatko was asking me about questions about our Solar Connect purchase power agreement and some issues that we've had with the developer. Even as near as we have a proposed construction or operational date of mid-February, that's actually supposed to be online by the end of December. We had a contractor come to us and say they might not complete it. Even after you have your things in place, sometimes things just happen and facilities don't get completed. So your final decisions can actually change even after you have approval.
Okay. All right, I was just thinking I was remembering that wrong because I thought that case had already been filed and was going along before the ETA was enacted. Correct?
Yeah, I can't remember the exact case number.
17-00044.
You have that memorized.
I do. There was a time several years ago I could tell you all the cases. No longer.
Yeah, there was once in my history too. I could tell you every case I worked on.
Okay. Ms. Sakia, thank you. Any redirect, Ms. Lees?
Yes, Your Honor.
Okay.
Ms. Sakia, do you remember Ms. Coleman questioning you about the recommended decision in case number 15? I'll tell you. Just a second. Yep, 15-0083 UT.
I do, but I don't remember which OPL exhibit that was. Is that
Okay.
6?
Yeah.
But I know Ms. Coleman didn't admit it.
So go ahead and open up that exhibit. It's OPL exhibit 6.
Okay. I have that.
Okay. And do you remember Ms. Coleman asking you if Nextera was the only bidder that responded to that RFP discussed in the recommended decision in case number 15-0083 UT?
I do.
Okay. Can you go to page 16 of the recommended decision?
Okay. Page 16 at the bottom of
Yeah,
that.
the internal pagination of the document.
Okay.
And there's a bullet point list, and then there's a paragraph that follows that. Can you read the first part of the first sentence of that paragraph? Basically, you don't have to read further than the comma after entities.
Following its review of the 104 bids received from both distribution and transmission voltage entities, SPS selected 2 bids submitted by Nextera.
Yep, you don't have to keep reading. I just want to clarify for the record, Ms. Sakia, you didn't recollect how many bids were received by SPS when Ms. Coleman was asking you those questions, correct?
I did not.
And it seems that this recommended decision does clarify how many bids SPS reviewed, correct?
It does.
Okay. And that number was 104 bids, correct?
Correct.
Ms. Sakia, can you please open OPL's Exhibit 7 That's the EIA exhibit that Ms. Coleman had you review.
Okay.
And do you recollect Ms. Coleman asking you that this exhibit demonstrates that the cost of solar energy has been going down between 2013 and 2018?
Correct.
To clarify, this just represents the cost of construction, correct?
The title is Average U.S. Construction Costs for Solar. So, yes.
So does this graph at the top of OPL Exhibit 7 for solar voltaic include all costs of providing solar energy to customers?
Based on the title, I would not think so. I don't think it would include ongoing O&M, transmission, interconnection, landowner, all of those type of costs.
Okay. Do you know what the trend for interconnection costs are in the SPP, what they've been doing recently?
I think if I recall correctly, Mr. LC said this morning that those costs have been increasing.
Do you remember, recollect earlier today, Ms. Sakia, that Ms. Coleman and the hearing examiner were asking you about the current status of the rulemaking, which I identified as case number 19-00296?
Yes.
Okay. Is it possible, Ms. Sakia, that a NOPR may or may not be issued in that case?
Yes.
And is it possible that the PRC may decide to tailor an incentive to each utility on a utility by utility basis instead of addressing requirements in a rule?
It is possible, yes.
Either way, do you think SPS should be harmed by a slow rulemaking and its request for an incentive?
No.
Certainly, PRC could redesign SPS's incentive at a later date after a rulemaking has been completed, correct, Ms. Sakia?
Yes.
Do you recall, Ms. Sakia, when Attorney John Bogatko was questioning you, that you had some discussion regarding Mr. Pollock's chart on page 10 of his direct testimony?
Hold on, let me open is Mr. Pollock's testimony exhibit 2? Yes. Oh, no.
It's OPL exhibit 1.
Hold on. Okay, I'm at Mr. Pollock's page 10.
Okay, and in your response to questioning by Mr. Bogatko, you stated that this shows the levelized cost of electricity going up between 2022 and 2025?
Correct.
And do you know why that levelized cost increases between 2022 and 2025?
I can't speak exactly to why. I would suspect that part of the reason is that at least currently, both the ITC for solar and the PTCs for wind are either set to expire or decrease substantially.
And the ITCs and PTCs, you're talking about tax credits, correct?
Correct.
Let's go, Ms. Sakia, to your rebuttal testimony on page 21. Do you recollect there was some confusion regarding why you attached the legislative red line version of the Energy Transition Act to your testimony?
Yes.
Okay. Can you read on page 21 the sentence starting on line 16 and ending on line 17 that's footnoted?
Wait, can you ask that again?
Yeah, sure. Can you go ahead and read on page 21 of your rebuttal testimony, starting on line 16, that first sentence that starts with moreover and ends with optional?
Okay. Moreover, the legislature amended the REA by striking language making the award of an incentive optional.
And you footnoted that sentence, correct? And you attached the legislative red line to that sentence, correct? Was the purpose of attaching the legislative red line at that to demonstrate that, excuse me, I'm going to start over with that question. Was the purpose of attaching the legislative red line to your testimony to demonstrate that that optional language was struck in the previous version of the REA?
Yes.
Okay. Ms. Sakia, recs are banked only for a limited period of time. Is that correct?
Yes.
And how long is that period of time?
4 years.
Okay. So they are not indefinitely banked, correct?
Correct.
That's all I have, Madam Hearing Examiner.
All right, very well. I realize I took this. Well, actually, I didn't. Anybody have anything further for Ms. Sakia? Okay, I'm not hearing anything. Ms. Sakia, thank you very much. You're excused. And I will make sure that the court reporter has the conforming copy of the exhibit, so you don't have to worry about that. Ms. Lees, anything further from SPS?
Not at this time, Your Honor. Thank you.
Okay. I believe OPL has a witness.
Yes, Your Honor, assuming he is still on. Jeff?
I'm here.
Okay.
Hello there, Mr.
Oh, there you
Pollack.
are.
Hello there. Judge Hurst, how are you?
I'm doing okay.
Cool.
Yourself?
Excellent.
Very well. Melissa, would you please swear in Mr. Pollack?
Can you raise your right hand, Mr. Pollack? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Go ahead.
Mr. Pollack, do you have a copy of what's been pre-marked OPL Exhibits 1 and 2?
Yes.
And do you recognize Exhibit 1 to be your direct testimony and exhibits filed in this case?
Yes.
And do you recognize Exhibit 2 to be an errata that you submitted to that testimony?
Yes.
And including that errata, is your testimony still true and correct to the best of your knowledge today?
Yes, it is.
Your Honor, we would offer OPL Exhibit 1 and 2.
Mr. Pollack, are the answers to your questions true and correct to the best of your knowledge?
Yes, ma'am.
Okay. Any objection to what's been identified as Mr. Pollack's direct testimony as corrected by the errata, OPL Exhibits 1 and 2? Hearing no objection, OPL 1 and 2 are admitted. Ms. Coleman?
Thank you, Your Honor. We would submit Mr. Pollack for cross-examination.
Okay. I don't believe anybody had questions except for me, did they?
I believe that's correct.
Okay. And I just had limited questions. I just wanted to make sure that I understood your testimony. And the main question I had, well, let's look at page 8 of your testimony, Mr. Pollack. and you're answering the question posed at lines 18 and 19. Why do you conclude that SPS's review of publicly available solar PPA prices was insufficient? And at lines 23 and 24, you say, given that additional resources are not needed until 2025 to meet SPS's RPS requirements, there's no reason to limit the scope of the evaluation in this manner. That's your testimony, sir?
That's right. Yeah, in essence, there's no reason to rush a decision when it's really not, there's not a reason to make a decision at this time regarding the acquisition of additional renewable resources.
Did you read Ms. Sakia's rebuttal testimony?
Yes.
It seems, if I recall correctly, it seems to me that she's saying that the manner in which they were required to make the evaluation was compliant with what was required for them.
Not sure. Compliant with what? I'm missing a context. That's why I'm having a hard time answering your question.
And offhand, I'm not finding the specific reference. It seems, what I seem to recall, Mr. Pollack, is that I think generally that Ms. Sakia indicated that that the review, the pricing review that they offered was sufficient to do the evaluation.
Well, I mean, I can see that, you're trying to look at other, alternatives to see if the price is reasonable. That's certainly an important thing to do, but you need to compare apples and apples on a total basis. Acquiring these two projects, regardless of how you're going to account for it, you're still going to be paying over 4 cents a kilowatt hour on a levelized basis. So you really need to compare, if it's economical, you really need to compare that against the cost of other resources that could be used, the time frame that those resources are needed. And as you were talking about, referring to my table on page 10 of my testimony, it's pretty clear that the costs, for acquiring solar resources have come down quite a bit, and quite a bit below the levelized price of the contracts that they want to bring over from Texas.
Additionally, sir, on page 11 of your testimony, you're answering the question posed at lines 9 and 10. Can SPS comply with its renewable portfolio standard obligation in ways besides acquiring renewable resources? And you answer yes. SPS customers could potentially host new renewable resource projects, which would reduce SPS's RPS obligations. That's your testimony?
Yes, ma'am.
Are you talking about like DG or what are you referring to about hosting new projects?
So it's sort of like the examples I also cite a little after that in my testimony, where customers have actually physically installed renewable resources on site, and more and more customers are turning to those kind of options to to help meet their sustainability and other types of corporate goals. So it's certainly not infeasible for customers to want to bring a project or host a project or jointly work on a project with SPS that could inure to not just the customer's benefit, but also to SPS in terms of their ability to comply with the ETA requirements.
And what do you base this recommendation on?
The basis is on my observation that many customers that I've seen across the country have made decisions about either remaining on a particular site or locating new facilities in a given service area on the condition that the utility will be able to acquire enough renewable resources to meet most of the energy needs of those customers. This is a trend that's continuing and certainly accelerating to some degree. Many of the data centers, for example, have located in states where utilities have agreed to host projects and to essentially sleeve those renewable contracts, meaning allowed by the renewable power and sell that renewable power directly to the customer as a way to not only attract the customer to the system, make it also economically sustainable, and also to meet the customer's corporate sustainability objectives.
But did you base this recommendation on your knowledge of SPS's customers in New Mexico?
Well, I did cite there were several customers that are currently hosting renewable projects. One just happens to be a client, a refinery in Texas that's got a wind project on their property, and that's one of the ones I cite. So yes, it is based on knowledge of what customers in SPS's service area, some customers are doing, and an idea of potential that other customers may want to do the same thing.
So then the customers that you list on page 11 of your testimony at lines 19 through 21 are in fact SP, and on the next page, those are all SPS customers.
Yes, for the most part.
Do you know whether they're located in New Mexico?
I think there's at least one in New Mexico. The Mesa Land, I think, is in New Mexico.
And you think the others are in Texas?
Yes.
Okay.
Yeah, I list IKEA as several Texas projects, so clearly that's them. I don't think IKEA is behind SPS, but IKEA is, again, an example of a corporation that is wants to bring renewable resources whenever they site facilities.
Okay. Thank you, sir.
You're very welcome.
Ms. Coleman?
Yes, Your Honor, if I could just clarify a couple things. Mr. Pollack, Hearing Examiner Hurst asked you if the types of renewable installations at customer sites that you're addressing are the same as DG. Could you distinguish what DG would be relative to the types of projects you're talking about?
Well, the types of projects I'm talking about would be bringing, large scale solar, possibly wind resources, putting them on site and making use of the energy, much of the same way that, cogen used to be for customers back in the days when customers wanted to make their own electricity.
So as compared to what we usually think of as DG, it might be larger and at transmission voltage?
I think the scale would be a lot greater. And in terms of projects like the refinery and the data centers, we're talking about tens, if not hundreds of megawatts scale. So we're talking really about utility scale projects being hosted by customers.
And you mentioned that many customers are looking at this because of sustainability goals. By that, are you referencing what's known as environmental sustainability and governance requirements of their investors?
I think that's a phrase that's been coined for that purpose, yes.
ESG.
Yes.
And then finally, you made a statement that I believe you said it's certainly not feasible that customers would install on-site generation. I think, did you mean infeasible?
I meant to say it's not. It's likely, more and more likely as the technology improves and customers, see the benefit of it.
Thank you. Those are all my questions, Your Honor.
Very well. Anything further for Mr. Pollack? Hearing nothing, Mr. Pollack, you're excused. Thank you very much, sir, for
Thank you for your time.
Appreciate that. Mr. Drake?
Hello, I'm here.
You have a witness that had been waived, correct?
That's correct, ma'am.
Okay, would you like to offer that testimony, please?
I would like to offer for admission LES Exhibit 1, which is the direct testimony and attachments of Amanda M. Alderson.
And that was the testimony along with verification that you submitted last week?
Yes, ma'am, that's correct.
Very well. Any objection to what's been identified as LES Exhibit 1, Amanda Alderson's pre-filed testimony in this case? Hearing no objection, LES Exhibit 1 is admitted.
Thank you, ma'am.
Anything further, Mr. A?
Not from me, thank you.
Okay. Mr. Badacco,
Hearing examiner Hurst.
you have some testimony?
Yes, Mr. Higgins. I want to make sure we're not missing him.
We're not missing Mr. Higgins. I'm going to go ahead and take the
Okay.
staff testimony.
Thank you.
Madam Hearing Examiner,
Okay.
if I may, I'd like to call Alicia Leyba-Cicero to the stand, please.
Melissa, can you swear the witness?
Absolutely. Can you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Ms. Leyba-Cicero. How are you doing today?
Good afternoon. I'm doing well. Thank you.
All right. Well, I trust that you are in possession of two items that have been provisionally marked as Staff Exhibit 1 and Staff Exhibit 3, which consist of your direct testimony and your supplemental testimony, respectively. Is that correct?
Correct.
All right. Well, regarding your direct, which has been marked as Staff Exhibit 1, can you confirm and affirm that that is your testimony that was filed in this case on September 11th, 2020?
Yes, it is.
And what you have before you, Ms. Leyba-Cicero, is that a correct and accurate copy of the testimony that was filed in September?
Yes, provided given the clarifications provided in my supplemental testimony.
Okay, thank you. And can you affirm that the information in the direct marked as Staff Exhibit 1 is correct and accurate to the best of your knowledge, information, and belief?
Yes.
And if you were asked the same questions today that are posed in the direct testimony, outside, leaving for the moment the supplemental testimony aside, would your answers to those questions be the same as we are here today in this public hearing, Ms. Leyba-Cicero?
Yes, they would.
Okay. Well, then I would ask you the same questions regarding your supplemental testimony, which has been provisionally marked as Staff Exhibit 1. Number one, first of all, is that a correct and accurate copy of what you filed as supplemental testimony on October 16th, 2020?
Yes, it is.
And are the opinions and positions that you set forth in that supplemental testimony correct and accurate to the best of your information, knowledge, and belief?
Yes.
And would your answers to the questions posed in the supplemental testimony still be the same as we sit here today, Ms. Leyba-Cicero?
Yes, they would.
All right, with that, Madam Hearing Examiner, I'd respectively move for admission of the direct testimony of Alicia C. Leyba-Cicero, marked as Staff Exhibit 1, and the supplemental testimony of Alicia C. Leyba-Cicero, marked as Staff Exhibit 3.
Any objection to what's been identified as Staff Exhibit 1, Ms. Leyba-Cicero's direct testimony? Hearing no objection, Staff Exhibit 1 is admitted. Any objection to what's been identified as Staff Exhibit 2, Ms. Leyba-Cicero's supplemental testimony? Hearing no objection, Staff Exhibit 2 is admitted.
Madam Hearing Examiner, clarification, if you'd indulge me. The supplemental testimony has been marked as Staff Exhibit 3.
Okay, 1 and 3.
Thank you.
Very well. Staff Exhibits 1 and 3 are admitted. And due to the time crunch we're currently in, pretend, Ms. Leyba-Cicero, that you are the Friday afternoon witness. And basically, if you could just turn to your testimony on page 4, and you're answering the question posed at line 8. Did SPS satisfy its RPS requirements for 2019? And at lines 13 through 15, you say, they retired RECs that were either banked or generated in the compliance year to meet the overall 2019 RPS requirement. That's your testimony?
Yes, it is.
Do you know the percentage of each?
I don't.
Can you get that?
Yes, I could get that.
Okay. All right. Consider that a bench request, Mr. Badacco.
Yes, Madam Hearing Examiner.
I would like to know that. Any bench requests I'd like to have by Friday filed in this case. And with that, Ms. Leyva-Trucero, I'm going to cut my questioning short in the essence of time. I thank you. And anybody have anything further for Ms. Leyva-Trucero? Hearing nothing, ma'am, you are excused. Thank you very much.
Thank you.
For your participation. Mr. Badacco, would you like to offer the other testimony?
Yes, please. Thank you, Madam Hearing Examiner. I would offer the prepared direct testimony of Gabriella Dashino, who's been excused from appearing today. It was filed on September 11th, 2020, and provisionally marked as Staff Exhibit 2. And it's been circulated to everybody in the case pursuant to your pre-hearing memorandum order. And the next item I would move into evidence, if you'll indulge me, is the supplemental testimony of Gabriella Dashino, which was filed on October 16th, 2020. It's been provisionally marked as Staff Exhibit 4. And I would move that into the record if it pleases Madam Hearing Examiner.
And those were the exhibits that were circulated last week, Mr. Badacco.
That is correct. The direct testimony of Ms. Dashino was circulated on the day it was due. I believe it was October 15th, pursuant to your pre-hearing memorandum. And then with your leave, I filed the supplemental testimony of Ms. Dashino, which is marked as Staff Exhibit 4 last Friday. And both of these have been circulated.
Any objection to what's been identified as Staff Exhibit 2, Ms. Dashino's direct testimony filed in this case, along with verification? Hearing no objection, Staff Exhibit 2 is admitted. Any objection to what's been identified as Staff Exhibit 4, Ms. Dashino's supplemental testimony with verification as filed last week and circulated? Hearing no objection, Staff Exhibit 4 is admitted. All right, let's go back to Mr. Rushoff. You have a witness, sir.
Yes, I'd like to call Kevin Higgins.
Mr. Higgins, if you would raise your hand, and Melissa, could you swear Mr. Higgins in, please?
Absolutely. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Mr. Rushoff?
Good afternoon, Mr. Higgins. Could you please state your full name and spell your last name for the record?
My name is Kevin C. Higgins, Higgins.
And do you have in front of you a copy of what's been marked as Exhibit NMLCG1, which is your direct testimony and attachment in this proceeding?
Yes, I do.
And was this prepared by you or under your supervision or control?
Yes.
Do you have any corrections to make to Exhibit NMLCG1?
I do not.
And Mr. Higgins, if I were to ask you the questions presented in your direct testimony today, would your answers be the same?
Yes, they would.
And those answers are true and correct to the best of your knowledge?
Yes, they are.
Thank you. Madam Hearing Examiner, I'd like to move for the admission of Exhibit NMLCG1.
Any objection to what's been identified as NMLCG1, Mr. Higgins' pre-filed direct testimony as verified by him here today? Hearing no objection, NMLCG 1 is admitted. Mr. Rushoff?
Thank you. I would turn Mr. Higgins over for cross.
I believe that all other participants waived Mr. Higgins' testimony save SPS. So, Ms. Lees, you have brief questions for Mr. Higgins.
I do. Thank you, Your Honor. Good afternoon, Mr. Higgins.
Good afternoon, Ms. Lees.
Mr. Higgins, were you present for Ms. Stacchia's testimony earlier today?
Yes, I was.
And do you recall questioning by counsel for NMLCG, Austin Rushoff, regarding NMLCG exhibits 4, 5, and 6?
Yes, I do.
And you probably have access to those exhibits, but I'll represent to you that Exhibit 4 is SPS's response to RFI NMLCG 21. Exhibit 5 is SPS's response to NMLCG 22. And Exhibit 6 is SPS's response to NMLCG 23. Are you familiar with SPS's responses to those discovery requests?
Yes, I am.
Okay. On turning to your direct testimony, Mr. Higgins, on page 11 of your direct testimony, you explained your concern that the energy portion of the direct assignment of the Rosalind Chavez PPAs were not being properly recognized, correct? That was the concern that you identified in this portion of your testimony?
Correct.
Are those concerns resolved by Ms. Stacchia's testimony today and NMLCG exhibits 4 through 6?
I believe that those exhibits that you just referred to go a long way to resolving my concerns. I do believe that the responses provide the very kind of recognition of the credit that I believe should be provided for any directly assigned PPA cost to New Mexico. And the concern I've had is that I do not believe that the FPP CAC would automatically make this credit. But I do believe that the illustrative credit that was provided by SPS in discovery, if the FPP CAC incorporates that type of credit, that it would address the concern I raised in my direct testimony.
Okay, thank you for that, Mr. Higgins. And is it your understanding that New Mexico Large Customer Group and SPS generally agree, though, how the energy portion of that direct assignment is appropriately recognized or assigned to New Mexico customers through the FPP CAC? Looking at those exhibit discovery responses?
Yes, I believe if the FPP CAC is modified or incorporates the type of calculation that SPS provided in discovery, then I am in agreement that the calculation is appropriate and would provide the correct credit.
Okay. Thank you, Mr. Higgins. Madam Hearing Examiner, that's all I have.
Very well. Mr. Rushoff, anything further from you for your witness?
No,
Okay.
nothing further.
Thank you very much. We appreciate your
Thank you.
appearance, your excuse, sir. Anything further from New Mexico Large Customer Group?
Nothing further.
Okay. Do you have anything further from anybody else? I believe we already have the applicable dates for any post-hearing briefing. And to the extent possible, I would like some proposed a template for a proposed RD considering the expedited nature of the case. So to the extent parties can be in agreement about any proposed findings, or conclusions, I'd appreciate that. And if we don't have anything further, thank you to all for appearing here today. Melissa, thank you very much. Anna will get you the exhibits, and good luck on your 2 o'clock. I have that you got 5 minutes.
Perfect. Thank you so much for making it happen for me.
Thank you. We are adjourned. And thanks and goodbye.
Thank you, everyone.
Thank you, everyone.
Everyone.
Thank you.